a small introduction of HRL, and which is a human rights law network. It's a collective of Indian lawyers and social activists who provide legal support to the vulnerable and disadvantaged section of the society. It mainly works on child rights, disability rights, prisoners' rights, refugee rights, and many other human rights-oriented things. And I would like to thank Union of Jogesh Chandra Chaudhuri Law College to organize this meeting today. And I welcome all of you. And we will be discussing on use of law for safeguarding violations on human rights in India. So I would request all the audiences to stay tuned till the end, as it would be a wonderful learning experience for all of us. And without wasting any more time, I would like to call Aparajita Bose, who is working as a human rights activist in HRL, and also is an assistant director of HRL in Kolkata. Her works regarding the prisoner rights is remarkable. She's working like wonderfully in these fields. So please, Aparajita Di, the platform is yours.
সুপ্রভাত সকলকে। আমি একটু ব্রিফ ইন্ট্রোডাকশন দিই। আমি অপরাজিতা বোস, সোশ্যাল অ্যাক্টিভিস্ট অ্যান্ড অ্যাসিস্ট্যান্ট ডিরেক্টর অফ হিউম্যান রাইটস ল নেটওয়ার্ক কলকাতা। আমাদের সারা ভারতবর্ষে 23টা ইউনিট আছে যেখানে সমগ্র লয়ার এবং সোশ্যাল অ্যাক্টিভিস্টরা কাজ করে। আমাদের ফাউন্ডার ডিরেক্টর হচ্ছেন মিস্টার কলিন গনজালভিস, হু উইল বি টেকিং দ্য সেশন। মানে উই আর রিয়েলি প্রিভিলেজড যে উনি সেশন নিচ্ছে। যেমন কুশল বলেছে, আমরা বিভিন্ন ইস্যুস নিয়ে কাজ করি, যেমন চাইল্ড রাইটস, প্রিজনার্স রাইটস, অ্যাসিড সার্ভাইভারদের জন্য।
Sorry to interrupt, but you are not audible.
I'm not audible. Hello?
No, she's audible.
আমি প্রপারলি শুনতে পাচ্ছি।
She's audible. Please go ahead.
আমি শুনতে পাচ্ছি।
আমরা অ্যাসিড সার্ভাইভার্সদের নিয়ে কাজ করি। বেসিক্যালি আমাদের হিউম্যান রাইটস ল নেটওয়ার্ক হচ্ছে একটা নন গভর্নমেন্টাল অর্গানাইজেশন, যেখানে আমরা পুরো নিপীড়িত এবং যাদের ক্ষমতা নেই কোর্টে যাওয়ার, তাদের আমরা বিনামূল্যে আইনি সহায়তা দিয়ে থাকি। এবং আমরা বিভিন্ন ইস্যুস নিয়ে কাজ করি, যেমন কুশল বলল যে চাইল্ড রাইটস, রিফিউজি রাইটস, ডিসেবিলিটি রাইটস, পার্সন লিভিং উইথ HIV AIDS, তাদের যে আইনি সহায়তা সেগুলো দেওয়া, প্রিজনার্স রাইটস যেটা আমার মেইন ফিল্ড, আমি এটা নিয়ে কাজ করি। যারা মানুষরা দিনের পর দিন জেলের চার দেয়ালের মধ্যখানে আছে, যাদের কোনো আইনি সহায়তা নেওয়ার ক্ষমতা নেই, তাদের জন্য উই HRLN আর অলওয়েজ দেয়ার। সমগ্র ডিপ্রাইভড অ্যান্ড ডিপ্রেসড ক্লাস অফ দ্য সোসাইটি অ্যান্ড দ্য মার্জিনালাইজ সেকশন, তাদের জন্য কাজ করি। এবং উই ওয়ার্ক অন মাইনরিটিজ অলসো। আর একটা ইম্পর্টেন্ট থিং সকলকে বলে রাখি যে আমাদের কিন্তু ইন্টার্নশিপও হয়। আমরা এই ইন্টার্নশিপ ফেসিলিটিটা দিয়ে থাকি টু অল দ্য স্টুডেন্টস অফ ডিফারেন্ট কলেজেস। সো কেউ যদি ইন্টারেস্টেড থাকো তারা আমাদের সাথে যোগাযোগ করতে পারো। আমাদের সঙ্গে আছেন আজকে আমাদের ফাউন্ডার ডিরেক্টর কলিন গনজালভিস, হু ইজ দ্য সিনিয়র মোস্ট অ্যাডভোকেট অফ সুপ্রিম কোর্ট। উনি এক্ষুনি সেশন নেবেন। ওভার টু কুশল, প্লিজ ইন্ট্রোডিউস। Kushal?
Hello, am I audible?
Yes.
Sorry, there's some network issue in my end.
Sir, can we introduce?
Okay. So our next speaker is Mr. Colin Gonzalez, who is a senior advocate of the Supreme Court of India, and also is a founder of our organization, that is the Women Rights Law Network. He will be speaking on law of sedition in India. Thank you, sir, for taking your time out for the student interaction. Sir, the platform is yours, sir.
Thank you. And good morning to all the students who are logging into this program. We are going to discuss today in a very practical way, in a very straightforward way, a section of the IPC which is very controversial. And all of you would have read in the papers that a bench of the Supreme Court recently made observations about this section 124 capital A, but in a restricted context of journalists. And I say restricted because journalists generally, and the media and the press generally, have a more favored status in society when it comes to protecting freedom of speech and expression. And I want to take it at a much wider level. I want to take very hard cases, because it's obvious that the press have a great latitude in writing about people and events and so on. Does that latitude extend to the lay public? Does that latitude attend to young students? Do you have the same wideness of freedom when it comes to speech and expression as journalists have? Before I start, I would like to tell you the main features of 124A. Listen carefully. And I say this because the Bible in the police station, the Bible for police officers, is the IPC. And you turn to 124A, the policeman is going to decide on whether to register an FIR against a student for saying Azadi, as happened in JNU, or even against a journalist for criticizing the ministers. He will go by 124A. So look and listen carefully to the provision. Whoever by words, so pause a while, words are punishable. Mere words are punishable. Or by signs or visible representation. So a placard is punishable. A poster that you print is punishable. Brings into hatred. Hatred for your government is punishable. Or contempt. Contempt for your government is punishable. Or excites disaffection, lack of affection. So not just hatred or contempt, but even if you say words that bring disaffection, I no longer love my government, is punishable with imprisonment for life. So you can see what a poisonous section this is, what a lethal section this is, what a venomous section this is. And it has its roots in British law. This is virtually a British law section with some change here and there. Where if you say anything against the emperor, that by itself was punishable with life in prison. So if I say the king is a fool, or the queen is an idiot, let alone more serious statements against the monarchy, you would suffer life in prison. I think possibly in those days it was even hanging for creating disaffection against the crown. Right? Now, I want to start with a series of provocative questions to make you think. And these provocative questions are not in the air. They are very practical things that happen day in and day out. Suppose I were to say, I hate this government. Everybody in India hates this government. Everybody hates these ministers. Would it be sedition? The section seems to say so. Suppose I say that this government deserves the highest levels of contempt. Would it be sedition? Can an FIR be filed against you? It would seem so. But let's go a little bit further. Namboodiripad, the great communist leader in Kerala, said long, long back The only way to change society is to get rid of capitalism and go towards socialism. And the only way to get rid of capitalism is by armed insurrection against the state by the people, and a revolution which will get rid of capitalism and bring socialism. That's provocative, isn't it? And if I were in a live audience, I would ask you to put up your hands. How many of you agree that this is seditious? What number 3? Revolution, armed struggle, smashing the capitalist system and bringing in socialism. And Namboodiripad, in those days, where people's visions were broader and more humane, the Supreme Court sentenced him to 1 day custody of court custody. So he would sit in the court till the rising of the court. No life imprisonment for poor old Namboodiripad. The colonial times changed and India got freedom. And this section continued. It's very interesting to see that a section which is so tightly linked to colonial power and to the prestige of the emperor would carry over under democracy, and it carried over until 1962, when Kedarnath came into force. And it continues till today. The greatest democracy in the world, as our ministers are very prone to remind us, has this most pernicious section today. And the reason why we are discussing this today is because probably hundreds of persons have had FIRs filed against them, have been arrested, are facing trial for very innocuous things. For example, you've said something, you've criticized somebody, you've come out with posters. In Uttarakhand, I remember seeing a trade union poster saying Inqilab Zindabad, pulled down by the police, and the persons who brought out that poster were arrested. So many journalists came in just for criticizing government. And the best case is a case of a client of mine, Kishore Chandra from Manipur, who got so furious with his chief minister. His chief minister must have said something extraordinarily stupid. He told him to FO. To FO. The chief minister was so, his ego was so affected by that slang that he ordered his arrest. He was arrested. The section used against him was 124A. And he was kept in jail for 1 year. The bail was granted to him after 1 year. A simple thing like this. I mean, all that the judge had to do is look at Kedarnath. And I'll come to Kedarnath. Now say, Mr. Prosecutor, how is 124A made out at all? And I'll tell you the point straight away. Let's not wait for Kedarnath. Because Kedarnath says 124A, words, representations, not good enough. I'm going to read down the law, which means I'm going to put into the law my words. And the whole country must treat that section as if the words of the Supreme Court are embedded within. And that requirement was violent actions against the state. So not only hatred for the state and so on, contempt for the state, by itself not good enough. You can have hatred. Thanks to Kedarnath, you can say, I hate I have contempt. I have disaffection. Everybody create disaffection against the state by lawful means, which means no violence. Create hatred, mobilize, change this government by lawful means, no violence. So all that became perfectly okay. Except policemen don't read the law, policemen don't care for the law, and policemen don't implement their law, they implement the orders of their ministers. So the person who should be caught and put in jail actually is the minister who gives that instruction. But we don't have the courage to do that. The minister who gave the instruction to the Director General Police, put this journalist in jail, he has criticized me, is the man who should be taken and put in jail for giving those instructions. So Kedarnath introduced a very important add-on, which is there must be war-like conditions created against them. Not small actions here and there, some stone throwing here, some slogan shouting there, some hartal here, some dharna there. No, no, no. War-like conditions, violent conditions on a large scale. Disrupting public order. And when you say disrupting public order, you realize it's not just law and order. Some, blockade here, blockade there. No. On a substantial scale, there must be mobilization against the state for the overthrow of the state. Got it? Now, in Kedarnath, if you read Kedarnath closely, and Kedarnath, I'll give you the citation. 1962, SCR, Supreme Court Reporter, Supplementary 2, page 769. So the first part of Kedarnath begins with the Privy Council judgments that preceded the 62 decision of the Supreme Court. And there, when you read that, you'll see that the Privy Council benches were split. Some benches said, like Kedarnath said in 1962, many years later, that you need violent acts. But many benches said, no. A plain reading of the section makes it clear that mere words are good enough to attract the penalty for sedition. So Kedarnath observes and notices that there's a difference. The plain words. And when you look at a criminal statute, and this is very important, when you look at a criminal statute, you must think of it through the eyes of a policeman. A policeman will open his IPC, that is his Bible. He'll open it, he'll read it, he'll say, words are good enough. 124A doesn't say anything about a violent act, so he'll interpret it in a particular way. And so Kedarnath stepped in and read down the section and said, treat it as if the judgment of Kedarnath is part of this section. But that's not good enough. Because which policeman in a police station is going to have Kedarnath's judgment on his table? I don't think most of the commissioners of police are even aware of, or Director General Police are even aware of Kedarnath. Or if they are aware, and this is also possibly true, they would prefer not to pretend that they don't know what Kedarnath says. So they allow their police officers to do whatever they want, and they ask and they allow their ministers to direct case against A, case against B, case against C. Vinod Dua was one case, but there are journalists galore who are facing sedition. Now let's go to another equally controversial thing. Let's put it now even more plainly. There was a case from Punjab where a Khalistani activist came on the streets and shouted Khalistan Zindabad. Khalistan Zindabad, Khalistan Zindabad. We need a separate homeland for the Sikhs. We must mobilize our colleagues and comrades. And we must have Khalistan in India. Yes. So obviously he was taken in sedition. Obviously the policeman laid charges against him, had a trial in which it was obvious that he had said Khalistan Zindabad. It seemed to attract the section. He was convicted for life. Matter went up to the Supreme Court. And when the matter came to the Supreme Court judges asked, apart from shouting Khalistan Zindabad and encouraging everybody to form an army and form an independent state inside India, did this man do anything else? Did he throw a bomb? Did he fire an AK-47? Did he mobilize large numbers? And the answer given by the public prosecutor was no, he didn't do anything, sir. He kept shouting slogans. And this judgment is an important judgment for you to read because many lawyers, including senior lawyers, are not aware. And this is Balwant Singh's case, the acquittal, 1995, 3 SCC 214. It's a very provocative case. If you ask for secessionism, let's say, I don't want to be part of India, this country, this state should not be part of India, and so on. And you make certain statements like that, but you do no further violent act in furtherance of those statements and those views that you have. Now, you make certain statements like that. Now we'll go to the second case. This is a case from Kashmir. Good cases because these are the kind of untruths or wrong points of view that circulate in society. And it's very important that all of you 201 young lawyers who have logged in today, that you use the information I'm giving you and the citations I'm giving you and become champions for free speech. Spread what I'm telling you today, spread this idea throughout the country. Make it a campaign across all the campuses. Free speech, robust free speech, so that no one anymore has to think that his mind is shackled and his tongue is clamped down. You can speak ferociously, openly, aggressively, as long as you do not engage in violence. You might even make a foolish statement here and there about violence, as in this case of, as in the two cases that I'm telling you now. But you took no act. You did nothing on a significant scale to wage war against the state. That is the dividing line. If you do that, then you get punished within the law. No doubt. So please, young students, I'm taking the opportunity today to tell you to use whatever you hear today in a vigorous national campaign across the colleges. The second case is the case from Kashmir, where a Kashmiri came on the streets of Srinagar and said, we want Azadi. And Azadi used to be a terrifying word, no, in India. Anybody who talked about freedom from oppression, freedom from casteism, freedom from sexism, freedom from communalism, were terrorists. Police call them terrorists. Freedom from environmental pollution, the state coined a phrase, eco-terrorists. So the state, which is often, if I may confide in you, but you may suspect, state is often the biggest terrorist of them all, unleashing untold terrorism on the people. arresting people, putting them in, lathi charging them, beating them, scaring them, is very quick to call everybody else a terrorist. Very quick. And when you stand up for your rights and you win cases in court that this is not terrorism and this is freedom of speech, you cut down the ability of the police to persecute you. Like colonial powers, there's no difference often between the persecution by the Indian police and persecution by the British police. Possibly our Indian counterparts may be even more adept, even more ruthless in persecuting its own people. So he came on the streets and said, Azadi, promptly arrested, naturally, convicted, naturally. And he said we should have, he went a step further, call all our friends and we should get guns and, and we should get Azadi. And again, when it came to the Supreme Court, I must say the wisdom of those benches in those days, because the law was not settled. And the court asked, did he do anything apart from shout Azadi? They said no, and he was promptly. There are other judgments, but these are two of the most important judgments. And that judgment is, let me give you that, Bilal Ahmed Kalu's case. Bilal Ahmed Kalu, 1995, 1 SCR 411. Now we come to Kedarnath. So Kedarnath, as I told you, read down the section, right? But it carries on till today, because what does a policeman have in a police station? He has the IPC. So Kedarnath made a mistake, and we have gone to the Supreme Court, and a three-judge bench of the Supreme Court has issued notice to re-look Kedarnath's case. Kedarnath is unconstitutional only for one small part. Everything else is correct. The sedition requires words, but it also requires action. But the small part says, I read it down, I don't strike it off. And there comes in Kartar Singh, which is also a five-judge bench of the Supreme Court. Kartar Singh is 1994 3 SCC 569. This is where Kedarnath made a mistake, and Kartar Singh is correct, and Kartar Singh should prevail over Kedarnath. So possibly we need a larger bench to say. Kartar Singh says you cannot have a criminal law statute which is ambiguous and vague, which could result in the policemen giving different interpretations. Criminal law is not to be left to the varying interpretations of different sections of the state. If it is ambiguous and vague, it must go. It must be struck down and removed, so that the policeman will get in his IPC, he'll get a little addition or a new addition, he'll get deleted. 124. That is what we are working for. And start a campaign in your colleges for the repeal of 124A. It is also unconstitutional for another reason: obsoleteness. The law must change with passage of time, and courts must always take cognizance of the latest situation. Why is it used? It is used to penalize free speech. It's the only section where, despite 19(1)A, freedom of speech and expression, the state can merrily go about penalizing free speech. It is not interested in the other part. The state and policemen and politicians are not interested in the other part, whether you are going mobilizing against the state. Why? Because there are so many new laws that have come in after the the 62 decision of Kedarnath. You have UAPA. You have the Unlawful Activities Prevention Act. You have the NSA, the National Security Act. You have the Public Safety Acts in Kashmir and Chhattisgarh and so on. All of them are merciless acts. So does the state need 124A? Because people are mobilizing and, using violence against the state? Not at all. Not at all. So they don't need it for the violence part. They need it only because they want to terrorize people, terrorize journalists, terrorize young people, terrorize trade unionists, terrorize women's organizations, terrorize Dalit organizations, tribal organizations, terrorize them so that they shut up in free India. More lethal than the bomb is the tongue. For governments such as ours, merciless uniformly across the country, irrespective of party affiliation. Killers all. Subjugating people in ways worse than the British. Keeping us in hunger more than the British. Keeping us under surveillance more than the British. Lying to us and keeping us as slaves in free India. The strongest weapon against that is the tongue. That is why 124A, my dear friends, is very important for the state. Hold on to it, cling on to it. And they said, never mind Kedarnath, who is going to read Kedarnath? Book is there. The IPC is there. And so, my dear friends, I think my time is up. I want to encourage all of you to become revolutionaries, to become social reformers of the most dynamic kind. Because India is in turmoil and its people are in distress. You are the new generation. You must rise in revolt. I hope I don't have the sedition case filed against me. You must rise in revolt against the tyranny that we see all around us. Tyranny at all levels, not just government levels, all levels. Rise in revolt. Thank you very much.
Thank you, sir, so much for your wonderful learning experience, sir. So I would request Shankare from Student Union.
Yes, sir. So am I audible?
Yes, you are audible now, Shankare.
Okay.
So you
Okay.
are feel free to ask questions to sir.
Yes, sir.
Okay.
Yes, sir. Good morning. Good morning, Colin, sir.
Good morning, Shankare.
Good morning, sir. Thank you so much for such a wonderful experience we had right now. Thank you so much. So there are some questions from our students. I'll go by the questions one by one. So the first question is from was from Shayantan Kaur. The question so just one moment, it has gone up. Just 1 minute. Yes. So Shayantan is asking, how can the situation of Kashmir be made better?
Well, that requires another answer at another level. But at least you can make it better by, in keeping with the topic we're discussing today, by not doing mass arrests, not doing unnecessary arrests like we see in Kashmir today. Large scale arrest of people without cause, right? And that must stop. Using the law as a weapon to stifle freedom and democracy is wrong. So at least we can stand up for Kashmiris. For example, let me tell you, the internet, for example, is stopped routinely. Or there's going to be everyone will talk to everyone, there's going to be a lot of turmoil, rubbish. The internet is your fundamental right, so we must stand up for Kashmiris when that internet is blocked. So I'll give you a limited answer to that question.
Thank you, sir. So the next question that was given by Bibhashon Bishash. So he's asking, recently many stand-up comedians have been arrested for making political jokes on the government. Does that amount to sedition? Aren't they granted the freedom of speech?
Correct.
That's-
Now, after this lecture, I think the answer is already given. Because stand-up comedians have a greater license. A stand-up comedian has the license to mock, has the license to say things which are not normally said about sexuality, about the judiciary, about this, that, and the other. I mean, you can't have a stand-up comedian who's boring, isn't it? So stand-up comedians exercise their right in a manner which is much more aggressive. You might say it hurts me. Of course it may hurt you. A stand-up comedian has a right to say the things that are in some way hurtful. You think you have a case against him, you file a case against him. But can you have pre-censorship? That is to say, the moment he says something, you'll catch him, come on stage, catch him by the collar, and can't touch him. Free speech will go through. Then if you think he has defamed you or something, you can file your cases. And this law of defamation, criminal defamation, is also obsolete and unconstitutional. That should go. To threaten a person because a person is saying something, threaten him with criminal defamation. Like all these companies do. The moment you say there's environmental pollution from factory A, they'll give you a criminal defamation notice immediately. So you see, the stand-up comedian is protected completely. And now there are very interesting cases going on in respect of contempt of court. Because you'll say things which everybody talks about actually, but is never said publicly. But the stand-up comedian is going to make it public. Hey, I hear this about the judiciary, I hear that. And the judiciary, I think it is becoming, has become, may not be uniform, is growing with the times, is becoming more modern and understanding that, hey, people do make fun of judges. Hey, people are talking about what judges say and do. And yes, we may not have, some of us may not have the kind of respect we think we should have because our conduct is not up to the mark. So stand-up comedians are a very important group of people whose rights must be protected because they say what everybody else is afraid of saying, but with humor and laughter.
Thank you, sir.
Shankarit, for 1 minute. Actually,
Yes.
we have already exceeded our time. So we will be taking questions. Take your questions. We will, sir will answer later on.
No.
I would just.
Okay. No, it's all right. You have 1 or 2 questions more. It's all right.
Okay.
You can't have
sir.
a human rights session with military precision, you know. Take the questions, no problem.
So
Okay, Shankarit.
Okay, sir. Sir, am I audible?
Yes, you're audible.
Okay.
Take a few
So,
more.
Okay, sir. So this is a very important question, I think, because this directly talks about what we have the right. It's from Tanya Adhikari. She's asking exactly what kind of actions can be held as an offense under this act and what are not. What kind of actions can be held under sedition? Like for us students, how can we protest against the government or the wrongdoings that is happening around us?
See, the question is already answered actually, so I'll be very brief. When you see people who have said something, criticized something, and they are taken in sedition, you must immediately defend them. As simple as that. Because obviously the persons you come in contact with have not engaged in violence against us. So please just defend them, that's all. I'll make it crispy and short.
Okay, sir. So there's this one more question. This is from Rohini Roy. In cases where remarks are made in the context of certain minority ethnic movements, where the narrative is determined by a majoritarian group, do you think laws like 124A are almost always misused?
No, listen, when you make, let's say you make an anti-Dalit statement, you make an anti-Muslim statement, right? Sedition has nothing to do with this, obviously, because I've already explained, right? And sedition is to do with hatred against the state. But you make an anti-Muslim statement, you make an anti-Dalit statement, and the party in power, in fact, is a specialist in doing this kind of stuff. Right? You have other sections you have the hate speech sections, isn't it? So the hate speech sections say that whoever tries to create I'm giving you my own version, create a split or create hatred between communities, right? That's a crime. That's a crime. If you tell people, this should be done to this community, take the slogan, Desh ke gaddaro ko goli maro salo ko. It's hate speech. You must immediately, I would tell all your students, get a copy of that, go to the police station, say this is the statement made by so-and-so, this is the slogan he gave, this is hate crime. And do that. Desh ke gaddaro ko goli maro salo ko. Once we start litigating against these people and get them arrested, the slogan will stop in the obnoxious slogan will stop in the country. So on this, I think we'll stop so that we don't intrude on other people.
Sir, just it's my request. One more question.
No, 1 second. And one thing I want to say, please, to all your listeners, we are recruiting young lawyers. And so if there are people who are willing to risk their lives and do very interesting things in defending people, we are looking forward to meeting with them. I think you stop here because we are overtaking somebody else's time. So,
okay, sir. Okay, sir. Okay. Thank you, sir. Sir,
Thank
Kushal, sir, it's over to you, sir. Thank you so much, sir.
Thank you, sir, so much for your wonderful time, wonderful speech, sir. So our next speaker is Mr. Sabyasachi Chatterjee, who is a practicing advocate in Calcutta High Court and he's practicing for quite a number of years and also associated with HRLN. And it's very pertinent to mention here that he's also represented a lot of remarkable and reported cases in Calcutta High Court and as well as in Supreme Court of India. And he will be speaking on victimization of human rights defenders in India. Sir, Sabyasachi, sir, over to you.
I'm there. Thank you, Kushal, for the good words spoken about me. And it's my privilege to be with all of you, the students of Jogesh Chandra Chaudhary Law College. First of all, I would like to congratulate the Students' Union for holding this session, which is pertinent and which is relevant also in today's context, particularly when we are facing tremendous issues related to human rights. Human rights under the Constitution of India, according to me, it is the backbone of the Constitution. Without the human right, no citizen of India can stand and no citizen India can live here without the basic rights. That is the first recognition we want. But today, we are living in a country where the conditions and state of affairs of human rights are really, okay, I'll start my video. I was not starting the video because I was just traveling, and I will be telling you about so many things about human rights and violations, and particularly the protection of defenders, the specific issue which I have been asked or assigned to talk about. Now, as Mr. Gonzalez, while talking about sedition, has started with section 124A. We very recently have come across certain cases under 124A in the country, which started from JNE. That slogan of Azadi, placarding, as well as the issues related to any kind of protest. And the term which became very popular at that point of the time, that intolerance. Kindly remember this word, intolerance. One of the basic elements of democracy in India is the diversity and tolerance. Without diversity and tolerance, this democracy cannot sustain. That we have to keep in our mind, and we have to brown it in our mind. Now I will come to directly that why this intolerance attitude is also going and targeting the defenders who are defending the defenders also. Even the advocates, they are being dragged into the litigations. Think about Sudha Bharadwaj. Think about the people who raised their voice for the human rights movements. Think about Bhima Koregaon case. What we have seen in Bhima Koregaon cases, the many, the human rights watchdogs and human rights front runners, they have been arrested and they have been booked under UAPA. Can you imagine a lawyer being dragged under case under section any of them under unlawful activities prevention? He might have a very indefensible case. However, the lawyer has the right to represent that person. And one of the important that everybody must have a right to be represented through a lawyer in the court. Look at Article 22 of the Constitution of India. Article 22 provides that every person who is booked or arrested by the police will be produced before the court of law, nearest magistrate, within 24 hours. And he will have the right to be represented through a particular lawyer, and he has a right to engage his particular lawyer. You can see the constitutional scheme also framed under Article 39A through the TLSA and SLSA and other organs and the of the country, and particularly the free legal aid services which are provided. Today, we see there is a clear-cut threat on the representation of the lawyers too. Sudha Bharadwaj is facing. You have seen her daughter has written a letter that my mother is unwell. We have seen very recently the friend of us, Narula, who lost her father in COVID, just got 1 day parole and came out. Again, she was going back to the jail because of a particular case which is been manufactured against her. This is the status of human rights and defenders, the person who are defending the defenders in the country. Now let us think about this. What is this concept of defending the defenders? How this concept was evolved in our country? There are human rights documents published by the United Nations. I will referring to some of them. Clearly provides that what is the role of the human rights, the defenders, people who are defending their rights of the defenders, and defenders are basically the human rights activists, lawyer. They may be qualified, they may not be qualified to become lawyer, but they are activists. They're talking about human rights. They're helping the people. They're helping the people about basic human rights, except without considering the caste, creed, politics, color, everything. Equality before law, who wants to promote it and want to practice it. That person is he is the person who is to be considered as the defender. And it is very difficult. It is very difficult in today's India to protect the defenders. You have seen some of the cases in West Bengal too, that defending the defenders were very difficult. Not in last 10 years, 20 years, 30 years, 50 years. I will tell this is the feature which you have to understand from the Constitution. State. This is a system which is working. As Mr. Gonzalez was talking about the difference between pre-independent India and post-independent India. How this has changed, how the concept of police has changed. Are there so much sensitized about our rights. These are the things which has to be addressed. However, the proper sensitization programs in the police has not been done for a long time. That's why police people will never open the law book and
Sir, if
never
Bashajida.
look into the law and give arms to
if you can hear me,
the question from the constitutional angle. But what is happening? They will work under the dictate of their political bosses everywhere.
Shobhuda, can you hear us? Shobhuda?
Now this is a
Shobhuda, I think there has been some network issue. We are not able to hear you. The voice is breaking in between. Is he here with us or we have lost his connection? I think we lost him, right, Aishwarya?
yes, I
Okay.
think.
Okay, we'll just wait. Then let's just for a minute.
হ্যাঁ দাদা তো
Shankarit, if you're here, start taking
কুশল কুশল
হ্যাঁ বলো সন্দীপন বলো।
Yes.
হ্যাঁ
শুনতে
বলছি দাদার সাথে ফোনে
Sorry.
কথা হলো, নেটওয়ার্ক একটু প্রবলেম আসছে, দাদাকে যদি একটু পরে রাখা যায় খুব ভালো হয়, ইফ পসিবল।
Okay.
জাস্ট ফোনে কথা হলো।
we will try to do that. In the meantime, we will take the questions if Shankarit is here.
Yes, ma'am. Yes, ma'am. I'm here, but
But-
I can't see any questions as of now. So I would suggest to move on to the next speaker if sir is available, and then we can just move on to the next questions.
Correct. We'll just proceed.
Yes, sir. Yes, ma'am.
Okay. So we're moving on to the next speaker since sir is unavailable to us now. So our next speaker is Ujjani Chatterjee, who is practicing as an advocate in Calcutta High Court, and she will be speaking mainly on challenges faced by human rights defenders during COVID-19 pandemic. So Ujjani, are you available? Are you here with us?
Yes.
Okay,
Am
wonderful. Over to you.
audible? Yes. A very good
Yes,
morning.
you are audible.
Yes, a very good morning to all of you here. It's a great privilege to be a part of today's program because it, an invitation from HRLN takes me back to a long memory lane, in fact. So when I had joined my college, I was from Department of Law, CU. So my first initial years of internship were at HRLN. My introduction to the whole concept of human rights were at HRLN. And they were incredible times. We've learned so much. And the best part of it was that we got to, it was not like an internship where we were just reading up books. We were actually dealing with the real issues. That was the first time I understood that there's a world outside the comfortable world that we live in. There's a world where people do not have access to many of the things that you and I do. They do not have access to this online communication that we are having right now. They do not have access to food, the way we call up Zomato and Swiggy and say, send us this, send us that, to private vehicles and a lot of things that they have to think twice before taking any decision in life that we wouldn't even think about. So that is the kind of exposure that I've had at HRLN, my first introduction to this whole idea that we live in these privileged cocoons and majority of the world's population live outside it and who need attention, a lot of attention, especially from the people like us, because we are privileged. Now, I was just hearing what Shobhoda was trying to indicate, and before that, even the topic on sedition. We are living in very tiring times, very, very trying times, and we are exposed to threats which are not just coming in the form of virus, but much more than that, which touch upon our lives very closely, things that we do not expect usually, or things that we've not seen maybe even 5-10 years ago. So stuff like, the cribbing upon our fundamental rights to speech and our expressing our opinions. I'm sure a lot has been spoken on that. I will not be on that. But what I have been asked to discuss is the challenges faced by human rights defenders. So working into this topic, I have also learned a lot of things which I would like to share. So the term human rights defenders, that has been acknowledged by the Human Rights Commission in 1998. There's in fact a day, 9th of December 1998, is celebrated as the Declaration of the Human Rights Defenders Day. So human rights defenders is the term had to be an acknowledgement for the large number of people across the world who have been working to protect human rights. Am I audible? Am I audible, everybody?
Yes.
Yes,
Wow.
yes, ma'am. You are.
Yes.
Yes, ma'am.
Here, so I just wanted to confirm. If I'm not, please indicate. Yes. So,
Definitely.
yes. So what happens with human rights defenders is that there are this group of people. Now, as we talk about human rights, we read about it in books. We've got the Human Rights Protection, the Protection of Human Rights Act. It has been largely covered in the Constitution of India. I'm sure as students, you've all been, you've read about it, you've learned about it, you've heard the term very often, like we all do. But what happens is, even while we know about it, we read about it, there are very few people who actually go ahead and do something about it. That's the kind of sensitization that is largely missing in our country even today. Not only in our country, I'm sure across the world. And if you look around you, see, we as lawyers, as law students, we are more aware of this term. We are more aware of the importance of protecting human rights. We know that there is this facet of our lives which need protection. But if you talk to other people who are not remotely associated with law, remotely associated with the Constitution, who are just laymen, they have interests in other fields in their lives, you will see that they are not even aware of it. They don't even know that this is also a huge part of a society which needs protection, where a lot of things are going on, that there are laws, there are policies, there are advisories, and there is this constant movement that's happening in our society trying to protect human rights. So I feel that as much as we are here discussing today, there is this lack of awareness in the larger society who do not know that human rights protection is required, and not just at the end of lawyers and law students. It can be extended by any person. Even an engineer can go out and tell that there is somebody, my neighbor is in need of some protection from maybe domestic violence. So that kind of sensitivity is still largely missing in our society. A small fraction of it, we talk about it, we're aware of it, maybe we know what to do. If we see somebody whose human rights are being violated, we know that, okay, we have to go to the police station and report something. For 9 out of 10 people, they will not even listen. They will say, okay, fine, we know there's something going wrong, but we really don't know what to do. Let's just go back to watching TV. So that's the kind of, I would say, lack of awareness that still haunts us. Now, with the pandemic, things have gotten worse. What has happened is all our focus from 2020 March, all our focus has been diverted to the disease and to the control of the pandemic, control of the spread of the disease, and to protecting ourselves, our families, and medication. So prior to 2020, if there was like 5% of the society even thinking about it, post the pandemic, 100% of society not thinking about anything except COVID. So everything has become difficult. Everything has become difficult in terms of implementation, in terms of execution, in terms of even, thinking about ideas, because every time you want to implement something, you know that you cannot do it because there's either a lockdown, or there are people who are unwell, or there's a chance of you contracting the disease, or the administration is not going to help you. Now, coming to administration not helping you is probably the biggest challenge that human rights defenders have faced. Human rights defenders have always faced challenges. I think it is the most challenging task ever to go out and protect someone's rights, which 10 other people are trying to curb for their vested interests. That itself is a task that is it creates surmounting pressure on the person who's doing it. And it's a bigger pressure because probably you're not fighting for your own human rights. When it's your own personal problem, yes, there is your own personal interest. But when you're trying to do it for somebody you do not know, it's a bigger pressure. There's administration coming and telling you what is your interest in it. And you don't want to explain, or you can't explain that you have no interest except to protect somebody else's human rights. So coming back to the pandemic, when these challenges were already existing, with the pandemic, we have seen that the usual cooperation of the administration towards human rights defenders have gone down, because then the priority has shifted to handling COVID. So the next question that will come up is, I understand that you are trying to protect someone's human rights, but please understand, here I am trying to implement the lockdown. So then the thing becomes as to problem of one person, who is maybe the person who is who's been inflicted some kind of violence, versus problem of the society at large. So the administration who is supposed to the human rights defenders, they are largely now occupied in dealing with the pandemic. This is issue number one. So they are, and you can't even tell them anything because the pandemic is such a big issue. So they will not prioritize the needs and the requirements of the human rights defenders, but they are going to prioritize what is required for implementation of a lockdown maybe. So they will not want to go out and extend their help towards you because they'll be like, we have other duties. Now, problem number two. Here again, the administration is not going to be able to help you because they will be like, we are already at the brink of contracting the disease from so many other places. So why should we go out and help you? It's a matter of couple of months. Let it ease down. Whoever is the victim, let this her, him, whoever it is, let them just handle this for a couple of months. Let things get better. Let a couple of cases go down, and then we'll help you. So this is second problem, that people are generally scared of going out and doing things which are absolutely not necessary. Now, what is necessary for a human rights defender is something that won't be necessary for everyone else who is really not interested in it. You get it? So it's like you really have to be invested in this job, in this endeavor to go out and protect somebody who is in need of protection, as opposed to somebody who will think that this is not even that big a deal. There are domestic violence issues going on, so many numbers. I mean, so what's the big deal? We have a pandemic to deal with. So with that kind of an attitude, implementation or even going one step ahead to protect someone's right becomes very difficult for human rights defenders. Now, the other problem that also I have come across, I was just going through a lot of advisories. Now, it so happens that our Human Rights Commission, it has recognized these issues in the last 1 year. It has recognized the amount of challenges that are being faced by human rights defenders. And am I audible? Yes.
Yes, ma'am, you are.
Yes, ma'am.
So what happens is that they have, I came across a list of advisories that have been issued by Human Rights Commission. You will also find them. I mean, I'm sure it's a great read for all of you, for you students especially. And they have recognized several issues that have continued, these problems that have continued despite the pandemic hitting the country. So something like human trafficking. So it hasn't really stopped. So I was very surprised myself that, even amidst a strict lockdown, even amidst a complete loss of, people being confined in their homes, there are certain crimes which have really not stopped. So human trafficking happens to be one of them. There are still people who are subject to it. There are find themselves in a completely unprotected environment, and to make things worse, because of the pandemic, they have very little access to human rights defenders themselves. If under normal circumstances, I could have gone ahead and protected maybe 10 people. Now, because of the pandemic, I can only go ahead and protect 2. So my movement, my access to all of. Am I audible? I think there's a network issue.
You are, ma'am. Please go ahead.
I just saw a message that there's a problem. So
now
please tell me. Okay.
Yeah, you are.
Yeah. So what happens is, I was just going back to it. Yes. So that is the difficulty where these victims do not, yes, I will come to it, how to stop domestic violence. So where these victims do not get access to human rights defenders themselves. So advisories have been issued by the Human Rights Commission, where a large number of people are trying to work in an organized way and they are trying to address these issues. And it is so wonderful actually to see that these kind of steps are being taken even amidst a huge pandemic that I think our country is largely failing to cope with. But keeping that aside, anyway, now the biggest problem right now, I mean, keeping all of this on one side, and for me, what I have seen as a lawyer, the biggest problem is our restricted access to law and justice. Now, you're budding lawyers, all of you over here, you're law students. I mean, I'm sure the thrill of going to courts and wearing your gown, moving a matter, fighting for a person, that is the thrill behind everything all, no matter what we say. When that is taken away from you, as lawyers, as law students, it's a part of a power. It's in fact the biggest power that you have is taken away from you. Now, for a human rights defender, whether it be, they can be a lawyer or a non-lawyer, whoever it is, ultimately, what is it are we fighting? We are fighting for the implementation and protection of our rights. Now, we know that the protection and implementation of our rights, the ultimate safeguard of these rights are the courts, the courts, the judiciary. Now, in the last 1 year now, more than a year or so, from March 2020 onwards, there has been a complete breakdown, I would say, of the usual regular functioning of the courts and judiciary. It's undeniable that we are trying very hard. I mean, I'm at the other side of the bench. I mean, of not, other side of you right now. I've gone into the court. I know that our institutions are really trying very hard to keep access to justice as much possible. But even there, it is not possible for us to meet the needs of the majority of people. The way we used to function prior to 2020 March and the way we're functioning now, there's a huge difference, huge. I mean, we are functioning at probably 5% of our strengths. And it's really so difficult because the judges are not able to come to courts. The lawyers cannot go to court. Most importantly, we cannot even file so many matters that we would under normal circumstances. That, if there is a problem, we immediately go ahead and file a public interest litigation, a writ petition, a complaint for domestic violence issues, as you was just saying. So there was this very ready access to lawyers and judges and courts, which has been completely restricted because of the pandemic. That is a huge blow to human rights defenders. Apart from the fact that, we've been, we are dealing with all kinds of administrative impediments, challenges because the police doesn't want to help us, or for whatever reasons there is prioritizing COVID over all these issues. The fact that we cannot go to this independent authority, which is the judge, which is the judiciary, we cannot go to the court because they are supposed to hear our grievances. The fact that we do not have access to that kind of justice, it's the biggest blow to the human rights defenders at this point of time. And unless the access to justice becomes regularized, it becomes more, I would say, convenient and feasible for the rest of us, this challenge is going to continue. The fact that human rights defenders will face these challenges and they will find it very difficult to get the reliefs, the actual reliefs to the victims, it's going to continue. It's a harsh truth. No matter how hard we try, but this will continue for at least for another year or two. That's what I fear, in fact. I hope I'm wrong. Now, coming back to, again, one of the other challenges that I was thinking about, I read upon this advisory on mental health. Okay, before the mental health, I'll talk about the domestic violence issue because I think somebody wrote on that. Now, yes, there's an advisory on that as well, domestic violence issues. Now, what happens is, this is actually very interesting in the sense that if you, Oishani Mitro, okay. So now what happens is, under normal circumstances, when people are going to work, families, I'm talking about maybe lower middle class families, or actually doesn't matter from which family you come across, because if you have the intention to cause domestic violence, it can happen from any economic section. So families, when they're under pre-pandemic times, when we were going to work, we were involved in other things, even if there were issues between people, you could deal with it separately because you were distracted towards other things. So you had a regular family to run, or you had to attend to work. But now after pandemic, what happens is this the fact that everybody has to stay together in a home setup. Now, I'm sure it works out fine for most families where there are no problems or people are comfortable with each other's presence. They really don't want to kill each other. But there are certain families where the propensity of domestic violence has been there, but it did not surface so much because the people weren't really staying together for such a long time. But because of the pandemic now, these issues have surfaced. These issues are happening because first, you are not going to work. For example, say a man, he's not going to work. He is clearly frustrated with his life and he is very depressed. And in addition to that, he wants to take things out on his wife and children. And there is a financial crisis. And whoever it is who is subject to these kind of domestic violences, it's basically an outcome of your inner depression, I believe, because these instances of domestic violence, the perpetrators of these crimes, I think they need more mental help than anything else. It's a matter of rehabilitation for them. So when you don't get all that, you are already a victim of mental health crisis, and you take that out on your partners. It could be either way. I'm not making this gender specific at all. I do not believe that domestic violence happens only upon women. These are not gender specific crimes. So when these things happen, you are not getting access to the police. If you are a victim, you're not getting access to the police so easily. Even if you do get access to the police is more interested in handling COVID than listen to you. The usual registration of complaint is impeded. It is largely restricted. Third, you're not getting access to human rights defenders themselves. Even if you call them, they come to you. It's a problem because traveling is difficult. It's a problem because they do not, the police again is unhelpful. And fourth, the biggest problem, you do not know how to get out of the situation yourself as a victim. I'm talking from the perspective of a victim. You do not know how to move out of your house and take the next step, because at the end of the day, you have to come back and stay in your house. It's difficult for you to get an order from the court, from protection officers, if you're a victim of domestic violence, because the courts are not functioning. Even though they are functioning on very restricted basis. You have difficulty getting access to lawyers. Even if you do get access to lawyers, it turns out that they are restricted themselves, because sometimes their offices are not running or they cannot go to the courts themselves. So with all these factors working together, which were not there prior to March 2020, the whole situation has escalated to a different level altogether. So the problem which was at level 10 prior to March 2020 has now reached level 90 because of these extra factors which were not there before. Your overall access to law and justice, your overall access to implementing a smooth program has now been completely disrupted. So as a human rights defender, as well as a victim, all of these issues will happen. Okay, guys, I need just 1 minute. There's this very important phone call. Can you please give me 1 minute? In the meanwhile, can you give me the question? Yes, guys, I'm so sorry. Yeah, hello, am I audible?
Yes, you are audible.
I'm really sorry. This was so urgent. I kept receiving calls, so I had to take it. Yes. So I was at restricted access to justice. Yes. So I think there are a lot of questions that have already come my way. So can I just open them?
Ma'am, may I help you by seeing out the questions aloud?
Yes, I have already opened the chat in any case. So you can also read out from there. We can just, interact. And I hope it's not a problem because I'm making it so informal. And
No, ma'am, absolutely not. Absolutely not. Ma'am, am I audible?
Yes, yes.
Okay. Good morning, ma'am. Thank you for such an informative session. It was really nice. I'm sure all the students over here and everyone present, they were really, really helped by your session. So I'll directly go to the questions. Sanjana is asking you, ma'am, how to stop domestic violence in this pandemic?
See, this is like, it's like magic. If I were a genie, then I would just stop it because it's not just during, am I audible? Yeah.
Yes, ma'am. Yes, ma'am.
So it's stopping domestic violence in the pandemic is not really not really the largest concern. The concern is to stop it at all. But as I was just saying, that very unfortunate that instances of domestic violence would actually increase during the pandemic. It is something of I would say, a side effect of a pandemic, dear, because I'm very deep the kind of mental stress that you go through, anybody goes through, these increase the incidences of crime in society. So when if you have that kind of a suppressed, frustrated mentality that you are going to take it out on anybody in your family member, then this will just increase because of the pandemic around. So we are not living in normal circumstances. We are already battling with a lot of issues. Now, domestic violence, unfortunately, is going to increase. You can tell everybody, first of all, your access to awareness has also reduced. It's the fact that we are having this, this webinar on this issue, and it's very important. But if you really come to think of it, can you say that this has access to a large number of people around us? First of all, I'm speaking very candidly over here. Some people will not be interested because it deals with human rights. As I was telling, very few people actually know about it. Even we know about it because we are dealing with it every day. But people who are not lawyers, who do not have access to these kind of information, they would not be interested. Secondly, a person, I would go very, very candid right now. A person who would be inclined to cause domestic violence would really not appreciate this webinar at all. They will be like, oh no, they are really talking about things that are going inside my head. As it is, I'm not going to work. I'm so frustrated at home. On top of that, I don't like my wife at all. And what better way to take out all my frustration than being cruel in all ways possible? That could be physical cruelty, it could be mental cruelty. So these incidences will only increase because of the pandemic. More now, if you are living with an abusive partner, the ultimate solution would really be to get out of it. There are very few instances that abusive partners really learn. We want to make it a rehabilitative setup in our country. We want to rehabilitate people, but it's a very long drawn process. If I have to talk about it, I could go on for hours. It all starts with parenting. So these issues, you cannot take up a fragment of this issue right now and say that, how do I stop it? These issues have very deep set, problems that have happened maybe from the childhood. It all starts with parenting, how you've raised your children, how they've grown up, what kind of education they've received, and how, the kind of, I would say, a kind of suppressed fears that have resulted in taking it out as a method of inflicting cruelty on your partners. So these issues cannot be stopped in the pandemic. It unfortunate, but it's the bitter truth that they will only resurface themselves even more. That injustice, that I'm going through kind of problem. I need to file a complaint before the court, and I cannot tell them that I tell them that. Is that a problem?
Ma'am, there has been I think voice is breaking in between.
Yes, am I audible now?
It is, but
very vaguely, but
Voice
you are
breaking.
audible, but you are very vague. The voice is very vague, right? I'm sorry.
I will just try and fix that.
Yes, ma'am.
Is it better?
Yeah, it is. It is. Please go ahead.
I am connected to the internet.
Yeah,
Is it
it is audible. It is audible. Please go ahead.
Yes. Yeah, just see if there's like, no. Okay. You can keep it open, maybe it's better. Thank you. Yes. So, yes. So, how to stop violence?
Ujjaini, excuse me, ma'am, I just want to interfere a little bit. The thing is that the time has already been exceeded. So I would request you to kindly wind it up in a short while. So
Sure. Please, thank you for the reminder. If I start talking, very difficult for me to stop the right. All right, please, we'll move on to the next question then.
Ma'am, there's a very big question waiting for you. It's from, just give me one moment. It's from Preeti Kumari. What
Yes,
are the rights? Yes, ma'am. If you can read, I'll also read it out loud for you. What are the rights of human right defender? Because sometimes to save someone leads, I guess it will be leads you to a problem. And also, ma'am, sometimes a particular case is of private matter rather than the human right violation, especially in India. Ma'am, are you there? I guess
She is frozen.
I
think
guess
Kushal, you can take it
I
forward.
think
I guess her bandwidth is low. The connection, she is not getting a good connection.
I think we have lost Kushal. Please take it forward.
okay.
Yes.
So okay. So I will like to take the anyway. The time has been exceeded. So I would like to introduce the next speaker, and who is nothing but our very respectable our professor, Dr. Somnath Roy, and who is a professor at Judicial Law College, and he will be speaking on judicial activism in India. So, sir, Somnath sir, are you available? Are you there? Hello, Somnath sir, are you there?
I'm there.
ভয়েস ব্রেকিং হচ্ছে
Am I
আমারও তো কি
audible? Hello.
Sir.
Hello. Hello.
Sir, sir, yes, sir, you are audible, but your voice is breaking, sir.
আর কিছু করার নেই, আমার এখানে নেটওয়ার্কের এটাই ট্রাবল এখন।
বাস এখন ঠিক আছে স্যার, এখন ঠিক আছে।
মাঝে মাঝে হয়তো ডিস্টারবেন্স করতে। শোনা যাচ্ছে তো?
ঠিক আছে স্যার।
ওকে,
শোনা যাচ্ছে।
আচ্ছা ঠিক আছে, তাহলে স্টার্ট করছি। A very good afternoon to everyone present. And at the very outset, I would like to convey my heartfelt thanks to the organizers, JCC Law College Students Union, as well as HRLN Kolkata unit, for inviting me today to say something on the issue that is on judicial activism in India. Though I know very little about it, being a student of Constitution, I would like to share something relating to this judicial activism in India with you all. Now, in India, we are having a federal structure, we know, though with some centralizing tendency. But in a federal structure, independent and impartial judiciary, it is one of the essential features. Therefore, in order to constitute a federal structure, role of the judiciary must be impartial, and definitely the judiciary has to be an independent one, free from all sort of influence from the other two organs of the government. And in India, we know that judicial review, it forms a basic feature of the constitution. And though the theory of separation of powers is not followed in India in its absolute sense, yet the judiciary plays a pivotal role almost in every sphere for protecting the rights of the citizens of our country. Similarly, here I would like to mention that India is having a democratic structure. Here we are having democracy, not dictatorship. And therefore, one of the essentials of democracy is to protect the rights of the citizens of India. And the Supreme Court, specifically the judiciary, the apex judiciary of our country, is the final protector and guarantor of the rights of the citizens of our country. So every step is taken by the Supreme Court for the purpose of protecting the rights of the citizens of our country. And with this view, our judiciary has become active for the purpose of protecting the rights of the citizen. And this is nothing but the aspect of judicial activism. So judiciary, by becoming active, tries to protect the rights of the citizens of our country and thereby render justice in all its manifestations as mentioned in the preamble to our Constitution. And justice, as mentioned in the preamble to our Constitution, is not meant for a particular category of people. It is to be rendered to all without any sort of discrimination, without any sort of differentiation. Everyone, whether he is a rich, whether he is poor, whether he lives in urban place or whether he lives in rural places, or whether the person belongs to a religion, a particular religion, whether he belongs to some other religion, irrespective of each and everything, every person of our country is entitled to be rendered with justice as one of the ideals, as stated as one of the ideals in the preamble to our Constitution. And justice in all its forms, all its manifestations, be it social, be it economic, be it political, whatever. And we will see or rather we can see the reflection of different types of provisions whereby no discrimination on the basis of social or economic background of a person is there. Now, by becoming active, judiciary has tried to protect the rights of the citizens, I have said. So how the process of interpretation. And we know our country, rather in a country where we interpret the laws. So the court is there to interpret the different laws which are existing in our country. Similarly, in the same way, judiciary has played a pivotal role in protecting the rights as mentioned in part 3 of the Constitution. Okay, so we will find that our judiciary has protected or has interpreted the term life and personal liberty under Article 21. And we know that Article 21, which is there in part 3 of the Constitution, deals with fundamental right. The chapter deals with fundamental right, as we all know. And Article 21 says that no person shall be deprived of life or personal liberty except according to procedure established by law. So the two terms, life and personal liberty, these two terms are mentioned in Article 21 as fundamental right. But when the Constitution came into being, at that point of time, life meant right to live only. বেঁচে থাকার অধিকার. Right of personal liberty meant right of physical liberty only. But now today the meaning has been expanded. And who has done this expansion? Our judiciary. We are definitely grateful to our judiciary for expanding the ambit, the scope of the terms life and personal liberty as stated in Article 21 of the Constitution. And the judiciary acting judiciously by exercising its judicial power, by exercising its power of interpretation and construction, has interpreted the terms life and personal liberty in such a way or in such a manner so as to include several other rights within the ambit of the terms life and personal liberty under Article 21 of the Constitution. Starting from Khadak Singh's case, there we have seen that right to life also includes or right to live with dignity. That has been mentioned, but subsequently it has been reiterated. The same concept has been reiterated. Yes. Hello.
Sir,
Hello.
please continue. Somnath sir, you are muted. Please, can you unmute yourself, please?
Yes.
Yeah, thank you.
Yes. Yes. Am I audible? শোনা যাচ্ছে তো?
হ্যাঁ sir, please.
Okay. Okay. যেটা বলছিলাম যে the concept of Khadak Singh's case or the verdict of Khadak Singh's case has been reiterated in, we will see, Francis Kodali Mullin versus Union Territory of Delhi. There we will find that Supreme Court said right to life does not mean mere animal existence. It means and includes the life to live with human dignity and also the other bare necessities which go along with the term life. বুঝতে পারছো, তার মানে the scope, the ambit of the concept of right has been expanded in this manner. Right to life does not mean mere animal existence. শুধুমাত্র বেঁচে থাকবো, that is not the essence of right to life under Article 21. It means and includes right to live with human dignity also, and not mere animal existence. শুধুমাত্র অ্যানিমালদের মতো বেঁচে থাকা is not life. Subsequently, we will find that in Olga Telly's case, Olga Telly's versus Bombay Municipal Corporation, which is popularly known as pavement dwellers case. There we will find that right to livelihood has been included within the ambit of right to life under Article 21 of the Constitution. Right. Right to food. This has also been, several other rights have been recognized within the ambit of Article 21 in this manner. Similarly, People's Union for Civil Rights, in this case, versus Union of India, in this case, right to food has been recognized. One more important thing, that is right of education. It was, now we know that Article 21 capital A is there in Part 3 of the Constitution, which has been inserted by way of amendment of the Constitution, by 86th Amendment of the Constitution in 2002. But before that, before 2002, before 86th Amendment, Supreme Court already recognized right of education of a person under Article 21 of the Constitution. For that purpose, we can refer the cases of Mohini Jain, that is the capitation fee case, where the Supreme Court said that right to education flows directly from right to life. Because without education, normal or the proper or meaningful right, rather meaningful right cannot be laid. This has been stated by the Supreme Court. Okay. Now, in Unni Krishnan's case also, right of free primary education has been recognized by the Supreme Court as part and parcel of Article 21. Then coming to prisoners' right, we will see that several case laws are there. In Sunil Batra 2 versus Delhi administration, there we will find
Somnath sir, voice break হচ্ছে.
Torture, custodial torture. Hello, am I audible now?
এখন ঠিক আছে স্যার, প্লিজ বলুন.
Okay. In Sunil Batra's case, we will find that the Supreme Court said that no cruel or inhuman treatment while a person or while an inmate is there in the correctional home. So in this case, we will find that a torture was there on the part of the jailer. Torture means very serious, violent form of torture was there on the part of the jailer to the inmates. সেখানে কিন্তু a letter was addressed to the Supreme Court, and the Supreme Court even accepted that letter, that what we say as epistolary jurisdiction of the Supreme Court. সেটাকে accept করে কিন্তু the Supreme Court verdicted that there shall be no inhuman treatment, no cruel treatment, no torture over the inmates of a correctional home. Moreover, in D.K. Basu's case, we will find that handcuffing is against the right to life. That is not permitted. And moreover, along with that, in D.K. Basu versus State of West Bengal, in that case, we will find that several guidelines have been given by the Supreme Court, which are to be kept in mind by the person in whose custody the person is there, the offender is there. তাছাড়া আমরা দেখতে পাই ধরো ইন হুসেন আরা খাতুন ইন শিলা ভার্সেস কেস the right to get free legal aid. A person who is poor, who is indigent, who does not have the affordability to bear the expenses of the court proceeding, that does not mean that he will not get any justice from the court. It is not like that. Justice is for all. Therefore, the provision is there for the purpose of providing free legal aid. Constitution is also in Article 39 capital A, we will find as DPSP it is there for the purpose of implementing that DPSP, the Legal Services Authorities Act has been enacted, that we all know. But apart from that, the Supreme Court has recognized right of free legal aid to poor and indigent person as part and parcel of right to life under Article 21 of the Constitution. It has been recognized. Moreover, right of speedy trial of the under trial prisoners. It is also a part and parcel. It is also a part and parcel of right to life, speedy trial, right to life under Article 21 of the Constitution. এটা MH হটস্পটের ক্ষেত্রে বলা হচ্ছে। আচ্ছা, তারপরে যদি আমরা দেখি, হ্যাঁ, আজকে দেখো, we all know that today is World Human Rights Day. World Environment Protection Day. World Environment Day today, 5th June. Because the first international document relating to protection of human environment, that is Stockholm Conference, it started on 5th June 1972. Therefore, 5th June every year is celebrated as World Environment Day. And right of getting pollution-free environment, right to live in a pollution-free environment has been recognized as part and parcel of, I should say, part and parcel of right to life under Article 21 of the Constitution. MC Mehta's case is there. Then we will find Subhash Kumar versus State of Bihar. This case is there, whereby it has been said right to life includes right to live in a pollution-free environment, right to pollution-free air and water also. তাছাড়াও we will find several other cases are there. We will see, judicial activism বলছি যেহেতু, I should say that in Rural Litigation and Entitlement Kendra Dehradun, in this case, which is popularly known as the limestone quarry case. There were a lot of limestone quarries in the Mussoorie Dehradun region. And due to operation of these mines, the ecology was disturbed. And since the ecology of the place was disturbed, the rights of the people were hampered at that place, I should say. সেই জন্য the Supreme Court verdicted or gave direction even the closure of certain limestone factories, limestone mines, I should say. তাছাড়া দেখো আমরা Velo Citizens Welfare Forum, এই কেসটাও যদি আমরা দেখি, there we will find that precautionary principle and polluter pays principle, all these are part and parcel of sustainable development, because we are developing ourselves. Our country is developing. It is not a developed one. It is still developing. And the development cannot be hindrance over any other aspect. Therefore, and development should be there, but not at the cost of others, not at the cost of environment. So we can enjoy, we can exploit our natural resources, but not at the cost of future generations. We should not exhaust the things or the resources in such a manner that it will disturb or hamper the natural resources of the country. Subsequently, there will be nothing for the subsequent generations or future generations. In the same way, we will find the absolute liability principle has been recognized for the purpose of protecting the rights of citizens in MC Mehta's case. সেটাও আমরা দেখবো। এরকম ভাবেই কিন্তু আমরা দেখবো যে ডিফারেন্ট কেস লস, মানে এটা যদি বলি এখন তো সারাদিন লেগে যাবে, different case laws are there in different fields for the purpose of protecting the rights of the citizens in our country. Moreover, one important aspect, that is judicial creativity. Judicial creativity is a part and parcel of right to of judicial activism. Judicial creativity example is public interest litigation. The strategy is public interest litigation. Through public interest litigation, the judiciary has come to the normal, I mean the common people, for the purpose of rendering them with justice. Now, for the purpose of protection of the women, we will find that several case laws are there, whereby women's rights, women's dignities have been recognized. সেখানে আমরা দেখবো বোধিসত্ত্ব গৌতম ভার্সেস শুভ্রা চক্রবর্তীর কেস, দেন ভেরি ইম্পর্টেন্ট কেস চন্দ্রিমা দাস, Chairman Railway Board versus Chandrima Das. There also we will find that dignity, the Bangladeshi woman who has come, she's a foreign national in our country, and she has been gang raped in the railway Jatri Nivas of Howrah. And the court awarded her compensation. Now this compensatory jurisprudence, this is nothing new, but it is judicial activism. How? Because if we see Article 32, we will find that the Supreme Court, for the purpose of enforcing the fundamental rights, the Supreme Court can issue any order or any direction or writ, including the writs in the nature of bole 5টা writer কথা বলা হয়েছে. Therefore, we can say that Article 32, under Article 32, remedy is not only the writ remedy. Apart from writ remedies, any other direction, any other order can also be given by the Supreme Court. The court just interpreted this unwritten part, this uninterpreted part of the Constitution, and thereby included within this phrase the compensatory jurisprudence, that is allowing of compensation to the victim whose right has been hampered under Article, Part 3, right, fundamental right has been hampered. সেখানে আমরা অনেক কেস লস পড়েছি, যেমন রুদাল শাহ's case we will find. In Rudal Shah's case, we will find that compensation has been awarded. The Nilabati Behera's case, police encounter mara gechilo Nilabati Behera versus State Orissa, the mother of the victim, the boy who was encountered by the police, the mother of that boy was awarded with compensation. Railway chairman railway board এর কথাটা তো already বললাম. So judicial creativity also plays a pivotal role for the purpose of protecting the rights of citizens. All these cannot be read or cannot be studied separately, because all these are very much related to each other for the purpose of, and the Supreme Court has used all these weapons for the purpose of protecting the rights of our country in order to maintain or the sustenance of democracy in our country. So that is all. This is a very short discussion for today. কেন কি এটা নিয়ে বলতে গেলে এখন অনেক কিছু বলা যায়, অনেক ডিফারেন্ট অ্যাসপেক্টসে জুডিশিয়ারি হ্যাজ ইন্টারপ্রেটেড ইন ডিফারেন্ট ওয়েজ, সেগুলো বলতে গেলে কিন্তু অনেক কিছু ইনক্লুড করতেই হয়. তো ফর দিস শর্ট টাইম অফ টাইম দিস ইজ অল. Okay.
Thank you so much, sir, for your wonderful informative speech. So I think, Shankari, is there any questions, or I should?
Yes,
move
sir.
on to
Yes,
the
sir.
next speaker?
Yes, sir. There's just one question that someone is given it. Sir, Somnath sir, good morning, sir. Thank you so much,
Yes.
sir.
হ্যাঁ বলো.
Yes, sir. Hearing you once again, it takes me back to our college classes. Alas, we can't do that anymore nowadays. So, sir, there's a question from Ritam Shah. He's asking how to draw the line between the judicial activism and the parliament's wisdom in enacting a statute in an instance where parliament enacts a statute and the court intervenes and declare that such statute ultraviolates the constitutional scheme.
আমাকে আরেকবার একটু দেখো, এটা কি চ্যাট বক্সে দিয়েছে? হ্যাজ দ্য কোশ্চেন
Yes, sir.
given in chat box?
Yes, sir. If you
দেখি দাঁড়াও.
absolutely, sir. So you can open the chat box and the question is right there, the last one.
How to draw the line between the judicial activism and the parliament's wisdom in enacting a statute in an instance where parliament enacts a statute and the court intervenes and declares that such statute ultraviolates the constitution. আচ্ছা, হ্যাঁ ঠিক আছে, দেখেছি কোশ্চেনটা। শোনা যাচ্ছে তো শঙ্করী?
Yes, sir. Yes, sir. Yes.
এখানে একটা কথা বলি যে of the three organs of the government, first and foremost thing is that judiciary has been kept separated from the other two wings of the government, as stated in Article 50 of our Constitution. Judiciary has been kept separated. Therefore, when a statute is enacted by the parliament or any legislature, that can be questioned before the that can be challenged before the court of law. That's the constitutional validity. Its constitutional validity can be challenged before the court of law. And if it is seen that it is unconstitutional, it is derogatory with any of the provisions of the constitution, then that statute, the entire statute, or even a part of that statute can be declared null and void. And moreover, এখানে যেটা আসল ব্যাপার সেটা হচ্ছে what is usually done about regarding the pre-constitutional laws, it is just overshadowed because subsequently if the provision is amended, then the thing which was already there that can come into the picture. And regarding the judicial intervention, what the judiciary verdicts, it is applicable for that particular case. In the case where the judgment has been given, that specific judgment is for that specific case because the judgment has been given based on the facts and circumstances of the case. Yes, the concept of precedent is there. Precedent is a source of law. We do acknowledge precedents. We do recognize precedents. We do respect precedent, for which in subsequent of similar kinds of circumstances, precedents are, referred by the advocates before the court of law in order to draw an inference, to help the court to draw an inference in that regard. That is the basic thing. That is the main thing. And there is no asset drawing of line between the parliament's wisdom and judicial interpretation, because these two things are totally different things. Parliament has been given the power to legislate, whereas judiciary is something different. It just interprets the laws. For the purpose, I am saying, for the purpose of protecting the rights of the citizens of our country. Okay, that's it.
Thank you.
Okay,
Thank you so much, sir.
Thank you, sir.
Thank you so much, sir, for your answer. So, moving on to the next speaker, I would like to introduce Mr. Orko Kumar Nag, who is also an advocate in Calcutta High Court. And I guess Orko is with us. Orko, over to you. Are you there?
অর্কদা আসছে, এক মিনিট টাইম দেবে বললো, আসছে।
Sir, since we have 1 minute, there's one more question for Somnath sir. Sir, are you here with us?
আছি।
হ্যাঁ স্যার, আরেকটা কোয়েশ্চেন এসছে যে আরেকটা কোয়েশ্চেন এসছে স্যার, আপনি জাস্ট অডিওটা অন করে রাখুন, তাহলে আপনার কানেকশনটা বেটার হবে। ইট উইল মেক ইউর কানেকশন বেটার। হ্যাঁ So the question is, yes sir,
is some way limit the performance of the legislature? In what way? এখানে পারফরমেন্স অফ লেজিসলেচার এর উপরে তো জুডিশিয়াল অ্যাক্টিভিজম তো লিমিট ইম্পোজ করছে না। ইট ইজ নট লাইক দ্যাট। The judiciary is not imposing any limitation on the work of the parliament. Parliament যে লটা তৈরি করছে, that is general in nature. That is applicable in general sense, and judiciary is doing something different. সেখানে কিন্তু মানে কোনো ইন্টারফেয়ারেন্স বা লিমিটেশন কিন্তু হচ্ছে না। হ্যাঁ, এখন পার্লামেন্ট, এবার এই পার্লামেন্টে যদি দেখা যায় যে আনকনস্টিটিউশনাল জিনিসপত্র হচ্ছে বা আনকনস্টিটিউশনাল কোনো ল পাস হয়েছে, তখন সেটা তো ডেফিনেটলি চ্যালেঞ্জ হবেই কোর্টের কাছে ফর দি পারপাস অফ কোয়াশিং ইট। ঠিক আছে?
Okay, thank you sir. So I guess Orkota is here. So Kushal sir, it's over to you.
So Orko is here, and Orko will be speaking. Orko Kumar Nag, he will be speaking on judicial proceedings on PILs. So over to you, Orko. Orko, are you there? Are you able to listen? Are you able to hear us?
Am I audible?
Yes, you are audible.
Yes sir, you're audible.
So I do not know whether I am being visible or not. Yeah.
Yes, you are visible. Okay.
So let's, before I go into the topic of the day, that is the public interest litigation, I think the previous topic was Somnath who was going around and who was giving an idea with regard to the judicial activism. So the basic idea, if we see, of a public interest litigation comes from judicial activism. It was the judicial activism which brought us to the helm of affairs with regard to the public interest litigation at large. Public interest litigation, which actually had started in the United States through the matters of the judicial activism, got a different arena and a different aspect altogether when it came down to the greatest democracy of the world, if we can call it that way. So before I go into the ideas of public interest litigation with regard to the judicial proceedings, let us primarily discuss with regard to the human rights, which is the basic topic for the day, the use of law for safeguarding violations on the human rights in India. So what are the violations which we primarily face, which can be and which is a part of public interest litigation so far India is concerned? So we have to first analyze the factor that when we are talking about public interest litigation, every high court, even the Supreme Court of India, has its rules. So with regard to filing of a public interest litigation, there are certain aspects which we need to keep in mind and which we need to identify when we are instituting a public interest litigation over the entire, like over a particular topic or over the judicial, or bringing it to the notice of the judiciary. So what is the primary objective of a public interest litigation, if I may say? The primary objective of a public interest litigation should be to bring it before the writ court. The writ court in this sense would be the Article 226 court or Article 32 court, whichever we are talking about, whichever is in the parameters. So let us first discuss primarily the proceedings in 226 court, because that is the maximum arena, maximum scope of public interest litigations, because 32 public interest litigations has a different concept altogether. So let us talk about the 226 court. So when we are talking about Article 226 court, the writ court has to be like brought before a particular topic, a particular issue, which is required to be taken care of by the judiciary, and which the judiciary will not get a chance to adjudicate if it is not brought by some third party before the particular court concerned. So now this is a very simple kind of a Am I audible?
Yes, sir, you are.
Yes, Orko, you're audible. Please continue.
So you're muted.
Hello? Hello? And I think there was some
Yeah.
connectivity.
Now
issue.
you're
Yeah.
audible. Please go ahead.
Yes, go ahead.
Yeah. So the public interest litigation as I was talking about, when we are talking with regard to the concept of the issue which is brought before the court, this is a very simple way of defining public interest litigation, that there is a particular issue. That particular issue cannot be brought before the court by the people who are suffering the issue, and a third party which has no per se interest in that particular matter brings it before the court and gets that adjudicated. Now, what will be that issue and how you define that you are not a part of it? So it is a very simple concept. The simple concept is whether a person, when he or she is bringing or instituting a public interest litigation before an honorable writ court, they need to keep three things in mind. First, the issue concerned should not be specific to a person or specific to a, specific to a need of a person. It should be on a larger perspective. Now, to define this, there would be obviously few questions in many of your mind. That, for example, if there is a illegal construction going on, just beside your house. So if you are filing a litigation, whether that will be in public interest or not. So when you are affected by that illegal construction and you are approaching the court, then that particular litigation cannot be called as a public interest litigation. However, when you are approaching the court by saying that, look here, that there is a particular area, maybe a panchayat area, maybe a municipal area, maybe a corporation area. In that particular area, there are constant irregularities in making of buildings and making of the constructions. So now that becomes a very pragmatic issue. It might be you are a resident there. It might be that one of the illegal constructions is even putting difficulty to your life and liberty. Like maybe your sunlight to your house is getting obstructed or something. But if it is so that it is not only one house, it is a cluster of houses, many buildings all around the particular area is be found to be built in an illegal manner. It built in a manner dehorsed the rules of the building rules of the particular area. Then that issue turns out to be a public interest litigation, and a third party or even a party who might be affected by one of the buildings can bring it to the notice of the court, saying that, look here, there is a problem, there is an issue concerned, and you need to check it whether the constructions taking place in the various arenas of the municipal area is according to the rules or not. And now if the court takes cognizance to that, the court will automatically take up its own machineries to see that whether the constructions are justifiable or not. Now the second issue, that where you are not affected in any manner, or it is not about your concerns at large, but there is a particular point which needs adjudication. Like I remember appearing for the state of West Bengal, a matter where the issue was that whether the state government can give grants to the Durga Puja committees from the state largesse. Now, what is state largesse? So, state largesse is the property of the state, which actually belongs to all of us. It is the exchequer at large. So, what the point there was that whether the government from the state exchequer can go ahead and distribute 10,000 rupees to each of the puja committees or not. So now when it came down to the public interest litigation, it was first taken up by the Honorable High Court at Calcutta. The adjudication was that the government was giving this money in an aid and in a concept to the point that there was a Save Drive, Save Life campaign of the government, and that was being used as the reason of propagating that particular arena, and the government was giving that particular grant to all of the puja committees. Now, if we look into the adjudication part now, the courts adjudicated that as the government is doing something with regard to making an advertisement, not an advertisement for commercial purpose, but an advertisement in order to ensure that people at large are made aware of the of a scheme of the government, which is basically the point to look into the matter that whether the driving and the rash drivings and the roads and the road safety points are taken care of. So the government did not do a mistake at large, if you can say that, and the courts did not interfere. It was allowed. So now, if you see that who filed the case, I exactly do not recollect the petitioner's name, but as far as I remember, the person was an advocate. He had gone ahead and he had challenged the particular issue in the court, and he did not have any particular interest, any particular any particular versions or any particular benefit or negativity to gain from that particular public interest litigation. So now the point is that how the courts will adjudicate when you come before the court, that whether you did your research properly, whether you did the issue you chose was absolutely without a business in which you are a part of. Business does not obviously means business per se, but business means an interest or a profit which you can make at large. So now let's come down to the proceedings. So as I was saying, when you are instituting a public interest litigation, the first point is no interest of the petitioner. Now the second point, which the public interest courts have also got a bit of, they have allowed the petitioners to be a bit relaxed, and that particular area is the research work. You do not come to the court expecting the court to go ahead and have and conducted a roving inquiry. You do not come to the court with the issue, and you do not come and tell the court that, look, this is a problem. You go ahead and you do whatever you want. You find out the problem and you solve it. No, it is not like that. When you are going for a public interest litigation, it is paramount important that you are done with your research. Your particular work, your particular petition should be covered with maximum, if not all, necessary points which the court needs to adjudicate, And that point should not be vague points. Like you don't go ahead in the court, like there was a public interest litigation, I remember, where a particular party, a particular person had filed, and the objection and the issue was that many of the political leaders have an undue advantage in their wealth. So that petition, I believe, I think it is yet to be adjudicated on the final notes. But the allegations, if that is the allegation, if that is the point which the public interest litigation court has to adjudicate, it has to be kept in mind that the research work done there has to be very specific, has to be very detailed, and has to be very vast. Because if that particular vastness is not there, then filing a public interest litigation only on mere assumptions and mere allegations would not work. Another point when we are when we are inviting a judicial proceedings in such an issue is that whether we are challenging the veracity and the bias of an act. An act or a statute or rules, I am not making much deliberations with regard to the meanings and the concepts of the act and statutes and rules, but the point
when there is sufficient numbers of public interest litigations with regard to challenging of any act, then the courts in 2013, the Supreme Court made it very clear that when you are before the court for the purpose of getting an bias of an act challenged, you cannot do that. And why you cannot do that? The reason is the concept of bias, that is the validity, the constitutional validity of an act of an rules, can only be challenged when you are aggrieved with that. If you are not aggrieved with that particular issue, you are not supposed to challenge it in any manner whatsoever. So the idea is very clear. The idea is that whether we are doing a matter before the honorable writ courts for the purpose of what do I say, to get an issue adjudicated. And now there is another very big problem which stands in the public interest litigation arena is media litigation. People come down and people go ahead and use the high courts and the Supreme Court to get a media attention. So those litigations, despite the fact that they are political litigations at times, happens to be taken up on public interest litigation arena, not because there is any indiscipline in the concept, but because the issues are of public interest. But at the end of the day, when it ends at large, when the propaganda starts with regard to the media and stuff, the judicial proceedings sometimes tends to get biased. But however, the point which I was harping on is when the public interest litigations go ahead and takes up interest which is politically motivated also, then the concept of public interest litigation gets vitiated. In my opinion, it is absolutely my personal opinion, when we are talking on public interest litigation, when we are talking on the Supreme Court's concept of public interest litigations, which is highly changing, because the precedents which was there in past, the precedents which was there in the older days, the concept and the laws which was, the concept and the rules which was taken care of by the courts while adjudicating public interest litigations are changing on an everyday basis. Because the arena and the concept of writ petitions and the arena and the concept of public interest litigations are getting so vast that precedents are not enough to keep it bind as well. There is a saying there is a normal saying that a judge is a judge and judge is a judge everywhere. So when a judge is a judge everywhere, the concept and arena and the concept of public interest litigation often sometimes tends to be a lot more than normal. And for an example, I would like to tell you, when Honorable Chief Justice, as his lordship then was, Janarand Patel, was the Chief Justice of the High Court at Calcutta, he had taken a trip to the North Bengal. And while he took a trip to North Bengal, he was actually going to see if I'm not wrong, the circuit bench site for Jalpaiguri. So while he was traveling there, he had to face a very bad road. The Chief Justice of the Calcutta High Court was so disgruntled to the entire situation. He was shocked to see the condition of the road. So when he came back in Calcutta, the first thing he did was, the next approaching Friday, he took up, he instituted a public interest litigation in his own motion, in his court's own motion. So that is the second and very important kind of a public interest litigation, you can say. That is the motions which is taken up by the courts to adjudicate issues. As I say, Janara and Patel had done that. Later on, during the Corona period, the High Court and the Supreme Court has taken a lot of efforts to take up a lot of matters per se. One of the main matters in the Corona time, in the COVID times, was with regard to the jail authorities matter, where the High Court expressed its concern whether the jail authorities are taking adequate care and whether the jails are have sufficient space to have the inmates during the Corona arena and all not. So the concept of public interest litigation, when it enters, that a judge is a judge everywhere, and when it enters to the concept that the courts can take it up on its own motion, gets more vast. The wide concept of the public interest litigation at that particular arena happens to be in a manner and in a particular format, in a way that the courts will interfere in anything and everything which the courts think fit and justified. So as I was saying, the second way of a public interest litigation, that is a court on its own motion, when the judicial discipline in this regard has to be kept in the highest realm. Because if the judges themselves who are looking into the issue do not take the particular aspect and the particular concept at the highest realm, then there is no way that the rules and the laws of public interest litigation can be used in a proper manner. The judges have to be very careful when they are taking up the matters on the own accords. Generally, it is the senior most judges who tend to take up matters on their own motion, but it does not mean that any other judge cannot do that. However, so far as rules are concerned, I would be sticking to the High Court rules. The High Court rule says that the Chief Justice of the High Court, or the acting Chief Justice for that matter, sitting with another judge in a division bench, will take up the matters with regard to public interest litigation is concerned. So the concept of public interest litigation in this particular arena is very clear, that whenever the courts are taking up matters on their own motion, it is the court which will adjudicate the issue, it is the court which will identify the issue, and it is the court which will put on the necessary parties on motion. Necessary parties on motion. So the point there to be adjudicated does not require the point of maintainability. Now I have entered the arena of the point of maintainability in the judicial proceedings of public interest litigation. So when we are talking about the point of maintainability, we have to be very clear that in this point of maintainability aspect, when a public interest litigation is adjudicated, it is generally the point that a filed public interest litigation, like when there is a petitioner and the court has not done it in its own motion, is the particular part when a particular point of maintainability can be raised. And now, what are the points of maintainability which can affect your public interest litigation in the judicial proceeding? One, I had already said that whether you are challenging the veracity and the bias of an act or not. Second is whether you are interested in any way to that particular issue or not. Third is whether the public interest litigation at large will help a particular area, particular group of people, particular cause or not. So until and unless the tick marks to the checkboxes are made, there is very rare chances that whether your public interest litigation can be entertained. The Supreme Court in recent times has not stepped back in imposing costs when there are false and frivolous public interest litigations. And now false and frivolous public interest litigations will obviously not mean I'm not categorizing. Of course, there are matters which is filed in personal interest and political interest to ensure public interest, or to at least prima facie show public interest. But I am talking about false and frivolous public interest.
Orko, I'm sorry to interrupt, but actually the time has been exceeded. So can we?
Yes, I am just concluding my point, Kushal. Thank you for the reminder. I was also apprehensive that how long I need to speak. Yeah.
Okay, fine.
As I was saying, and as Kushal rightly points out, that the time has expired. So the point is, when we are filing a public interest litigation, and when we are before the judicial proceedings, we are expecting a judicial intervention. We expect to do it well. Until and unless we do in a proper and structured manner within the bounds and rules of the public interest litigation, that should incur costs, because in our country, the judicial activism is for speeding up things, where the pendency of the cases is in a lot more situation. And in that particular place, when we are approaching the courts, if we are not ready with our research, if we are not ready with an issue which is not which is to be taken care of through public interest litigation, the courts should often tend to impose costs only to ensure that false and frivolous litigations in the name of PIL is not there. So I'm ready to take up questions, if any. Shankarit, I think, is moderating.
Yes, sir. Yes, sir. Thank you so much for giving your time, sir. Kushal, sir, can I just take one question? There's one question for Orko, sir.
Okay, fine. One question.
Just
is
one
okay.
question. One question. Okay.
Fine, fine.
So it's a pretty big question. Still, I'll read it out. It's from Ritam Shah. If a small part of a public footpath is usurped by some illegal structures, and such are impeding the ingress and egress in and out from a particular building which is standing in front of such small part of the footpath, and only a particular building is being harmed by such structures, but at large, common people are not being able avail that small part of the footpath. They are only left with to use the major part. Okay, it's a really big question.
Well, the point is, I have understood. The point is that
yes,
if
sir.
the ingress and egress of a particular building concerned is disrupted, and if the people staying in that building concerned believes that there is disruption, it is not only that somebody thinks like there has to be proper disruption with regard to the cars and all, then they will of course go before the honorable court, but that will be under the municipal head, because the ingress and egress of a particular building is with regard to the which comes under the municipal jurisdictions of the courts. However, if a public road is being encroached, then of course there is a chance that you go ahead and you approach the writ court and you ask for a intervention in the points of public interest litigation. But if a person staying in the building facing the problem of ingress and egress goes ahead and files a public interest litigation, then generally on a normal note, the courts should not entertain. The court should tell them that you go ahead and you get this adjudicated through in the proper forum. But as I was saying, Shankarit, and to answer Ritam, the vastness of public interest litigation is growing so fast that it might happen that the courts will take the main point that the government land, the public land is been encroached, and will direct the, I think as it is a particular road concern we are talking about, or a particular footpath concern, the government will go ahead and will ask the public works department and the municipal department to look into the matter, and if necessary to remove the encroachment as soon as possible.
Thank you so much, sir. Thank you so much, sir, for giving your time. Thank you, sir. Sir Kushal, sir, it's over to you, sir. Maybe invite the next speaker, please. Thank you so much, Orko,
Yes,
sir.
thank you, Orko, so much for the.
Yeah, so I think I can take a leave once. I will wait for a while, then I can take a leave.
Sure. So thank you, Orko, thank you so much for your wonderful speech and informations for the students. And we are moving on further. I would like to welcome Anirban Guho Thakurata, who is an advocate in High Court, Calcutta, who will be enlightening us on freedom of speech, on the topic freedom of speech. So, Mr. Anirban, are you there with us?
Yeah, I'm there. Hi, good afternoon.
Oh, Good afternoon, everyone. Over to you. The platform is all yours.
Yeah, thank you very much, Orko. Thanks for inviting us. Actually, this is actually you have taken me to the down memory lane because I was one of the students initially. I started my journey from JCC Law College, and the earlier speaker, Dr. Somnath, was one of my classmates. Though he was in the frontal part of the class and I was in the last part of the class, but we used to share the same classroom. However, I directly going to the topic. We are actually, I am talking about freedom of speech and expression. Am I visible? If anybody can say.
Yeah, you are,
Yes,
sir.
yes, sir. You are visible. You are
Yeah, thank you. Thank you. See, we were, Article 19(1)(a) has given a guarantee to, given a right of freedom of speech and expression. We all know that. And initially, whenever we study fundamental right, chapter 4 is one of the most important. Whenever we study Constitution of India, chapter 4 is one of the most important part of the Constitution of India, and we always concentrate on that. So actually, this freedom is one of the most important freedom. We all know there are other freedoms as well, but this is one of the most important freedom right now. Today's perspective, it has created a lot of what we can say, lot of things together. Right of freedom, freedom of speech and expression. Actually, freedom of speech and expression says about liberty of thought, expression, belief, and worship. We all know about these particular things, but we have this is not only the freedom itself, it is actually right to freedom. So we have to understand what exactly right is and what exactly freedom is, because it has not been defined anywhere exactly what right is. Right is something which we can claim from the authority and our moral, social, economical, this kind of things, what we can claim from the authority. And freedom is which we can utilize, we can use without even any kind of interference from the authority. This is actually freedom is. So freedom is much more vast than the right, and we Indian Constitution guarantees right to freedom of this other kind. One of the kind is freedom of speech and expression. So let us understand what you all know. We all know 19(2) has given some restrictions of this kind of this freedom, and these restrictions are very superlative in nature. Actually, these restrictions, if we can study, if we can look into the freedom by way of restrictions itself, then we can understand more freedom, because the area, the Lakshman Rekha that has been created by the restrictions, if this restrictions part, we go beyond these restrictions, all part of freedom. So restriction, we have to understand the restrictions first, and then we have to understand the freedom. So let us come to the illustrative part of what exactly freedom of speech and expression means. There are some, let us try to illustrate what exactly freedom of speech and expression is. Right to circulate and publish. This also has been treated as a freedom of speech and expression. So how come it can be, Dr. Somnath was my batchmate, she was talking about judicial activism. So freedom of speech and expression has been a regular subject of judicial activism, because this is one of the most important, as I said, this is one of the most important freedom that has been dealt with, and regularly it was being dealt with by the honorable courts of Supreme Court as well as honorable high courts. So let us first concentrate on the first one of the illustration of a freedom, that is circulate to publish. Like there are a lot of publishers, there are media, press everywhere. You can see now the media has gone in a very high number. Press, newspapers, they were publishing all through, and they were reporting many cases.
I think he is frozen, right, Kushal?
Yes, I guess so.
I think so, yeah.
Sir, Onivan sir, are you able to hear us? Sir?
I think there have been some issues. We'll just wait for a few seconds.
In the meantime, can you please call Onivan sir so that he may not able to know that he's frozen. I don't know. I am not pretty much sure.
Cipher.
কুশল আমি কল করছি দাদাকে
Okay, Sumit Chaudhary, thank you.
Mhm.
I think he has left the meeting, so he will be rejoining, I believe.
বলছি দাদা জয়েন করছে নেটওয়ার্ক ইস্যু হচ্ছে তাই প্রবলেম হচ্ছে
আমরা আরো 1 মিনিট ওয়েট করছি তাহলে ওনার।
জয়েন করেছে দাদা
Hello, am I visible?
Yes, sir. You are visible and audible both. Sir.
Thank you. Thank
Okay,
you very
sir.
much.
Please
Actually, I'm
continue.
sorry. There was a connectivity problem. So I was talking about freedom of press, which was dealt with by the Honorable Supreme Court earlier. And later on, this particular point was read, which is a very interesting point. The freedom of speech was guaranteed. Actually, this all freedom and all right has been guaranteed to the Indian nationals only, Indian citizens only. So this point was raised before the Supreme Court whether a non-citizen has similar right to press or not, which was dealt with by the Honorable Supreme Court. And in Bennett and Coleman and Company versus Union of India, it was a very landmark case when we were studying law. This particular case was one of the prime subject of ours. Their Honorable Supreme Court given a verdict that the person who is non-citizen has no right to press. So Bennett of Coleman was as you know, it was a non-citizen of India. They filed this public interest litigation, but unfortunately they lost that case, and it was decided that a non-citizen who is not a resident, non-citizen of India, has no right to press. It was a very landmark decision, one of the most important decision that then was passed. So right to conduct it was another very interesting subject altogether. Right to conduct interviews, whether a person has a right to conduct interview as a freedom, and that also includes in the freedom of speech on expression or not. So right to conduct interviews means a person has been, it was decided that yes, if the consent has been given by that person who is actually was the subject of interview, if he gives consent, then automatically it becomes a right to conduct an interview, and it also includes within the freedom of speech and expression. And it was decided by the Honorable Supreme Court in Prabhadat versus Union of India, where Honorable Supreme Court said that even two prisoners, the fact was 2 prisoners were tried to be interviewed going to the Tihar jail, and it was initially not permitted. Later on, they moved with the Honorable Supreme Court, and Honorable Supreme Court said yes, it is, if the prisoners really want to get them interviewed, then it is also within the ambit of freedom of speech and expression, and that has to be included also. So this again, there was a very serious role of the judiciary, who again elaborated and extended the ambit of freedom of speech and expression. I'm going to the third point, which was one of the most important, right to report judicial proceedings. That is also included in the freedom of speech and expression, but there are certain restrictions. As we can see nowadays, every media, everywhere, whenever a sub judice matter also has been reported, They were regularly reporting, but there are reasonable, I'll be coming to the reasonable restrictions later on. But this is also included in the freedom of speech and expression, and it was also decided in a Supreme Court case in Shri Mirajkar versus State of Maharashtra, where Supreme Court said, yes, the court may restrict the publicity of a case that is within the ambit of the power of the court. But if it is not restricted, then there is the media has a freedom of speech and expression. Media has the right to press where a matter is going on. So right to report judicial proceeding has also been included in freedom of speech and expression. Right to advertise, as we all know, everybody has a right to advertise their business. It also, there are other, it is also guaranteed in freedom of speech and expression. Most of the most important part of, I was talking to a friend, that right to portray social evil, right to portray historic events. Right to portray historic events means right to any filmmaker has a right to portray a historic event through his cinema. It is also a freedom of speech and expression. It is also an illustration of freedom of speech and expression, and it is also included. It has been also decided by the Honorable Supreme Court in, let me tell you the case. Yeah. Art Design and Technology versus Central Board of Film Certification. There was a case decided by the Honorable Supreme Court where this point was raised, whether Babri Masjid incident cannot be, whether it can be censored or not, whether this particular point can be elaborated or it can be cinematographed or not. So this point was also decided by the Honorable Supreme Court. Most important, and the freedom of speech and expression says not only all about speeches, it also says about silence. This is one of the most important things. Right to silence, whether it is also included in this freedom of speech and expression or not. Somebody doesn't want to speak anything, whether it is also included. We have all seen in criminal, whenever a person is arrested, he has been interrogated by the investigating agencies, whether he has a right to be silent or not. This also actually, law says, actually freedom of speech and expression says, he has a right to be silent. When there is a duty to speak, he has to speak, but when there is no duty to speak, he has a right to be silent, and that is also within the ambit of freedom of speech and expression. So this is one of the most important freedom that we enjoy being citizen of India, and there are some reasonable restrictions. Now I am talking, these are the illustrations. If any illustrations that comes to your mind, you can ask me by putting questions. Now I'll be talking about the reasonable restrictions on free speech and expression. So initially, what the restriction has been, as you know, that these restrictions actually has been created to keep a close watch, keep a close vigil upon the freedom and speech. If we human being has a common problem that we sometimes cross our boundaries. We don't know exactly what our boundaries are, and so whenever we need to enjoy our freedom of speech and expression, we need to understand what exactly the boundaries are, because these boundaries, whenever we start crossing these boundaries, that comes under the purview of legal issues. Sovereignty and integrity of India. We cannot question our sovereignty and integrity of India. That is a serious. That cannot be permitted throughout the territory of India. Security of the state and public order. That also doesn't. The law doesn't allow us to say anything about security of the state and public order. That is also very serious. Friendly relations with the foreign states. Friendly relations with the foreign land. We cannot question any relationship with the foreign affairs. Defense morality. We cannot question our defense morality, because you know the backbone of our nation is always their defense system, and we cannot question the defense morality. Decency and morality, which has been reiterated in Shreya Shingal's case. You all know about in 2015 there was a serious case where Honorable Supreme Court has struck down Section 66A of Information Technology Act, dealing with the freedom of speech and expression, where in Shreya Shingal's case, it was decided that anything which has been, I know all the students, everybody, we use social media platform and we have a right to express our voice. Nowadays, we are regularly raising our voice in different issues, different manners. Since Section 66A was restricting that, where Honorable Supreme Court said that 66A has no role to play because it actually restricts freedom of speech and expression. So Section 66A has been abolished in Shreya Shingal's case, where it was in the 2015, where two pertinent point has been raised. Not only Section 66A has been abolished, Section 69 and 69A and Section 79 of Information Technology Act has been given a priority. What Section 69A says, it says that intermediary means the Facebook authority, WhatsApp authority, they have a right to restrict, YouTube authority, they have a right to restrict the contents which actually is not sweating the content which actually beyond the restrictive limit. So it has been again reiterated by the Honorable Supreme Court in Shreya Shingal's case. And Section 79, where our authority, whether authority has a role to restrict with any content that has been uploaded in the social media. The Section 79 says yes, authority also has some role. And again, Section 79 has been given a priority. So 66A, a person has a right to express whatever his voice in social media. It has been decided in Shreya Shingal's case. It comes into the purview of freedom of speech and expression. But again, there are two restrictive factors. One is Section 69A, where the social media company like WhatsApp, so YouTube, Facebook, they have a right to restrict contents. And Section 79, where Government of India has a right to restrict contents. This particular point, though Section 66A does not give...
I'm sorry, sir.
Yeah.
A little sorry to interrupt, sir. The time has
please.
already been exceeded, sir.
Yeah,
So
yeah. Thank you very much.
Shankar,
Thanks for this valued.
Yes, sir. Sir, just one moment. Thank you, Anirban sir. Just if you can take just one question. It was given to Colin sir, but I guess as you were speaking about freedom of speech and expression, so I guess this question is quite relevant. So
Yeah,
the question was given by Ottijamoy Mukherjee. Why are Umar Khalid and Sarjil Imam still in prison? Is their surname the main cause for this? This is a very sensitive issue. And
see, India, we cannot go beyond the constitution as well as preamble, where our preamble itself says secular state. It is a secular state. So I am sure, pretty confident about our judiciary that the surname cannot be a reason of they being into imprisonment. So because we all worship, including our judiciary, they also worship our Indian constitution. So it cannot be a fact. I don't think so. There are other reasons.
Okay. So last, just one question. Sir, am I audible?
Yeah, please.
Okay.
Yes,
So this last one question, it's from Bibhashan Bishash. He is asking that so many movies and so many series are being banned. So where does the freedom of speech, this freedom of expression lies over there? If they are
now
banned.
there's a new act that has come into force in 25th February, the Information Technology Intermediary Guidelines and Digital Media Ethics Code, Rules 2021, that is introduced in 25th February this year. So there is a guideline that has been created for this OTT platform and everywhere. Contents has been rechecked and that can only be uploaded only. That is the reason some of the serious contents that has been stopped for viewing.
Okay. Thank you, sir. So this just one moment. This is a very important question. This is very relevant right now. Okay. So it's from Siddhant Sharma. The new IT rules say that the government will have the right to take down any content on news websites against which a complaint has been filed. Is it not against the freedom of press? This is very important.
See, that was the point was I was taking on. Shreya Shingal's case, it was decided Section 79. This new rule actually has been created from Section 79 of Information Technology Act. It is already there in Information Technology Act. So it was again reconsidered in the Supreme Court in Shreya Shingal's case, and in Shreya Shingal's case, Honorable Supreme Court has given priority to this. It means that it comes under the Article 19.2. It means it comes under the restrictions that has been created in Constitution itself from freedom of speech and expression.
Okay, thank you, sir. I guess the time is up, so I'll just
thank you very much. Thanks for the nice conversation that we had, and I love to go to the college again and give a short briefing, whatever if I can help.
So we hope so. That everything reopens.
Thank you very
soon.
much.
Thank you, sir.
Thanks.
Over to you, sir.
Thank you so much, Honorable Sir, for your wonderful contribution and information which you have shared with us. Moving on to the next speaker, I would like to invite Neil Basu, advocate, who is an also practicing advocate in Calcutta High Court and also been doing many important cases, representing many important cases. So, Neil, are you there? Neil will be speaking on right to privacy in India. So, Neil, over to you. Are you there with us?
Just a second, Nilda will be there. Just I'm calling it.
Okay.
কি হলো নেটওয়ার্ক প্রবলেম তাহলে আচ্ছা
Shankhorit, are you there?
Yes, sir.
Is it possible for you to contact Neil? I don't
Yes,
know
sir.
whether.
Okay, sir. I'll give him a call, sir. Yes, sir. I had called him. He's connecting. He's just joining in just a few seconds, sir. He's just joining.
Hello, Neil. Are you there?
Yes, I'm audible.
Yes, you are audible.
There was a network issue, I think. That's why.
Okay. Neil, I would just request you to keep your speech within 12:45, 47, so that because Subhasachida was there.
Sure.
You should let Neil continue for some time. Let me hear Neil. I will
Okay, sir. Okay, sir. Okay, sir. Neil, so Neil, you will be speaking on right to privacy in India. So please continue. The platform is yours. Neil, please continue.
Thank you. First and foremost, a very good afternoon to all the participants in this webinar, and a warm regards to all the speakers who have eminently spoken about the different ways for safeguarding the human right in this juncture of the society. And as the different laws that has been laid down in India regarding the different rights, human rights that are to be protected in the Indian context. And I have been given the topic of right to privacy. And at this juncture, right to privacy has become a very important topic, not all over India, but in an international perspective. But right to privacy in India has a great history. It is since 1950s, then in 1960, 1970 onwards, there has been development in this concept of right to privacy. And more particularly, when we say that whether a right to privacy is a fundamental right or not, as a student of law, all of us know that Part 3 of the Indian Constitution provides for fundamental rights to its citizens. And such fundamental rights are always enshrined under the Part 3 of the Indian Constitution. So this question, this simple question, all through in the Indian judicial history as well as in the law of our country came up, that whether right to privacy is a fundamental right or not. Now, starting from 1960s, when one of the important cases came up, rather in 1950s, the MP Sharma case, in which 6 judges bench of the Honorable Supreme Court was of the view that right to privacy is not a right, or is not a rather a fundamental right as provided under Part 3 of the Indian Constitution. Next, regarding in the case of Kharak Singh versus State of UP, this was again another important case in which the Supreme Court again upheld this view that was been taken in the MP Sharma case, stating that right to privacy is not at all a fundamental right, and that was again an 8 judges bench order. So these were the orders that were been passed by the Supreme Court in 1963, also in the Kharak Singh case, and as a result of which right to privacy was not given was not recognized rather to be a right under the Indian Constitution. So first and foremost, we must understand the meaning. What do we mean by the right to privacy? Whenever 2 people or 3 people are talking among each other, there may be some private talks which shall not be shared with any third person. Whenever, for example, for a simple understanding, if I am talking with someone, Mr. X, through WhatsApp message, where the WhatsApp message is end-to-end encrypted, that is the chat that has been done with me and that person are end-to-end encrypted, which means that nobody or no third person is there who could come and know what thoughts we are sharing among each other. And not a government authority, not a private authority has any right to know what we are chatting or what conversation are we doing. So every person in this country has their right to privacy. Though during the period, during these two cases, that is during the MP Sharma case and in the Khadak case, right to privacy was not taken into account as a fundamental right protected under Part 3 of the Indian Constitution. Then, through years, different debates and deliberations took place in the Indian Parliament, in both the houses of the Indian Parliament, most particularly the Lok Sabha as well as in the Rajya Sabha. Different cases came up, different petitions were filed. At different point of time, some high courts came up with the view that yes, right to privacy shall be given a sanction, shall be regarded to be a fundamental right protected under the Part 3 of the Indian Constitution. But such thing never happened until the 20th century came, and many cases in different high courts came up at that point of time, where many judges of the different high courts came up with the view that right to privacy shall be regarded to be a fundamental right protected under Part 3 of the Indian Constitution. Now, many of you are aware of the case of K.
Is Neil so frozen? Kushal, are you there? Typing. Can you see Neil,
Yes,
sir?
I am here. I think Neil is frozen.
Frozen. Okay. We'll just wait. Just wait. Yeah. I think Neil's here. Neil, sir, if you can hear us, please, I would request you to rejoin then.
There might be some connectivity issues, I guess. I will call him up again.
Yes, it's okay. I'm audible?
Okay.
Yeah, you are.
Yes, you are.
Yes.
Okay.
So
Yes,
K.
sir, audible.
Puttaswamy versus Union of India. K. Puttaswamy versus Union of India was a notable case because in this case, 9 judges constitutional bench was being formed. This 9 judges constitutional bench was formed in K. Puttaswamy versus Union of India just to decide whether right to privacy will be given a recognition of a fundamental right under the Indian Constitution or not. Because in the MP Sharma case, there was a 6 judges bench. In the Khadak Singh case, there was 8 judges bench. So a larger bench was required to be constituted. That is, a 9 judges bench was required to be, at least a 9 judges bench was required to be constituted to determine the fact that whether right to privacy shall be regarded to be a fundamental right or not. And thereby, in 2017, the Supreme Court 9 judges bench had upheld that yes, right to privacy is a fundamental right protected under Part 3 of the Indian Constitution. More particularly, on going to the judgment, it will be clear to you that right to privacy is a right protected under Article 21 of the Indian Constitution, which states that right to privacy falls under Article 21 of the Indian Constitution in conjoint reading with Article 14 as well as Article 19 of the Indian Constitution. And hence, right to privacy is a fundamental right as upheld by the Supreme Court in the retired Justice K. Puttaswamy versus Union of India case. Now, this right to privacy has been infringed throughout the ages in India in different cases, and different cases came up which says that there has been an infringement of my private privacy and I am approaching the High Court under Article 226 of the Constitution of India, or I am approaching the Supreme Court under Article 32 of the Constitution of India to enforce my right to privacy. And it was the K. Puttaswamy versus Union of India judgment which very deliberately stated that right to privacy shall be upheld. And in the recent times, most of you, I think that you have gone through the different articles that came up, and I will share with you a very recent upgradation that has taken place regarding the concept of right to privacy is that a new IT rule has been incorporated by the Ministry of Electronics and Telecommunication, Government of India, on 26th of May 2021. And this IT rule says that different social intermediaries, like social media intermediaries, like WhatsApp is a social media intermediary, like Facebook is a social media intermediary, like Twitter is a social media intermediary. So this social media intermediaries shall be subject to certain rules and regulations that are being enumerated by the Information Technology Department of the Government of India. And a case has been already filed by the WhatsApp challenging the IT rules before the Delhi High Court. And such petition is pending for adjudication, even though I would like to share certain facts that are being taken care of in that petition that has been filed before the Delhi High Court. They are saying the WhatsApp is taking the plea that their right to privacy has been infringed if the government is trying to identify the originator of a WhatsApp message. If the government of India is trying to identify the originator of WhatsApp message, then it is infringing the right to privacy of an individual. But what is the central government taking the stand? What is Mr. K.K. Venugopal appearing for the central government taking the stand? He is taking that, yes, originator has to be determined. Why the originator has to be determined? We are protecting the right to privacy, but with certain reasonable restrictions. Indian Constitution provides that all the fundamental rights are not absolute right. There are certain reasonable restrictions to those fundamental rights. And central government's argument in this case is that there are every time we are seeing certain fake news or we get scroll our WhatsApp chats, we find many forwarded messages which are giving fake newses. Often that is amounting to rioting, unlawful assembly, that is violence has been is starting from those messages. So the government says that we have to identify the originator of that message. That is the person who has written the message at first and who has forwarded the message to another, and from where the message became viral. The government wants to find out the originator to circumvent the chances of cybercrime, to lower down the risk of communal violence, to lower down the risk of the different communities. So this is something that is been that the government is trying to put in their argument before the Delhi High Court. And WhatsApp's single point agenda is that our right to privacy has been infringed. We are not in a position to say who will be the originator. If we are under the scanner of the central government, then people who are using the WhatsApp, over 50 lakhs people use the WhatsApp in India. They are under the scanner of the government. So their right to privacy has been infringed. Their right to privacy is infringed. We cannot allow their right to privacy to be infringed. Twitter is also taking the same stand. Twitter is also saying their right to privacy shall be infringed if the government surveillance is there. But I shall not comment anything about this case because this case is pending for adjudication before the Delhi High Court. But by all being a student of law, you all must be of this view that everyone has our private life. We have our private thoughts. We have our private freedom of speech, freedom for speech and expression, and such is obviously protected. And such right to privacy is essentially protected under Part 3 of the Indian Constitution, more particularly under Article 21, right to life and personal liberty, in conjoint reading with Article 14 and Article 19 of the Constitution of India. So whatever private life we have, whatever private talk we share with each other, that is protected. Whenever I am talking with Mr. X over a telephone, phone tapping cannot be taken care of. This was the first case that was been filed, the public interest litigation rather, that is the People's Union of Civil Liberty has filed a public interest litigation against the Union of India regarding the phone tapping. This was one of the cases from which the right to privacy concept came into being. So I hope that those in the webinar today had got a preliminary idea, or rather a simple idea about the right to privacy, that everybody being a citizen of India has our rights, has our privacy rights, and such privacy rights are to be enforced by the Indian Constitution. Under Part 3 of the Indian Constitution, if any of our right to privacy is infringed, obviously we can file a petition under Article 226 of the Constitution of India before the concerned High Court, or under Article 32 of the Constitution of India before the Supreme Court of India for enforcement of the right to privacy. Whenever I am talking with one of my friends over telephone, the government does not have any authority to tap my phone call, to get to know what I am talking with him or what I am talking with her. This cannot be. This is a right to privacy that is protected. Thank you, all of you, and I hope that I am been able to give you a certain overview of the right to privacy as protected under the Indian Constitution, safeguarding the right of the citizens in India.
Thank you so much, sir. Sir, just one question I have. It's from, we just have time for one question. I'll just read out the question. It was, just give me some time. It was a question from Siddhant Sharma. If WhatsApp finds a way to find the first originator without reading the content of the message, will it still be infringement of right to privacy?
No, as far as the government, as far as the IT rule is concerned, that is being published by the Government of India, Ministry of Information and Technology, is that the government will just may ask the WhatsApp team to provide the originator of the message. Originator, by this we mean the person who has encrypted the message, or the person who has typed the message at first and that send it. The originator only, not the persons who have forwarded, but the originator, the person from whom the message has originated. The government can ask.
Sir, your voice is breaking. Nilda?
Neil, your voice is, yes.
Your voice was totally off. Okay, so just one more thing. This is very important, this question.
Yes.
Can the call records, which are being recorded without permission, can they be used as evidence? This is a very pertinent question to this matter.
Very, very important question. Very important question. Call recordings, when it has been depicted in this case, that is the People Union of Civil Liberties versus Union of India. If you go to the judgment, that is the ordering portion of the People's Union of Civil Liberties versus Union of India, it has been categorically stated that the central government can only take those call recordings, or any government authority can take only those call recordings which is a threat to the national security, which is a threat to the life of any person or any authority of our country. Only those call recordings can be taken note of, not any call recording. Whenever, if I am talking with the moderator over the telephone after this webinar ends, that call, if it's been recorded, and if such recording has been taken into the custody of the government, such shall be violation of the right to privacy. But if I am talking over talking to a person and asking for developing an armed rebellion, or I am trying to externally weaken the country or the national security of the country, then that call recording the government can have to its custody.
Okay. So this was about the government. What will be about us? Like, for example, I am talking to you, or I am speaking with you over phone, and then any one of us records that call. Will that call be can that call be used as an evidence later for something? Or
no, for something like if in my call, if I am giving you a threat, like I am threatening you with dire consequences, that I can use my men and agents to kill you or to harm your family for some of the other reason, then you may approach the court and use that call recording. That is permissible. If I am threatening you, if I am doing something or telling something that will harm your dignity, that will harm your wellness, that will harm you and your family, and I may have an opportunity to do so. In that case, if you may approach the police, that is the cyber cell, more particularly saying of the concerned police authority, like if you approach the Kolkata police cyber cell and says that Mr. Neil Basu advocate is threatening me to kill me and my family for some of the other reason, and you approach the proper forum of law, then of course you can.
Okay, thank you, sir. Thank you, sir. Thank you so much, sir.
Thank you so much. Thank you.
Kushal,
Looks
sir.
like a lot of questions is arising. They are still coming up.
Sir, I don't think there is much time today anymore. It's already
Yes, sir.
12:57. Yes, sir. Kushal, sir, please proceed with the further things.
I know very well. I know this is a very important topic, but this very pertinent that a lot of questions will come up. But unfortunately, we don't have enough time. So we would like to conclude. Our meeting, our webinar has come to an end, and we would like to conclude our webinar by giving thanks to Student Union of Judicial Law College. I don't know, because I am an alumni too. I also belong to the college. I'm really thankful to all the students who have patiently participated in the meeting, and they have really participated well. So really thankful to Student Union. And Shankarit, if you want to add anything.
Yes, sir. Sir, I'd like to take this opportunity to thank everyone, to thank HRNL, to thank JCCLCSU, to thank the legal webinar team of JCCLCSU. The whole thing we need to know is that we need to be humans enough to work for the humanity. We ourselves need to be humans enough. So I guess this was a really informative, totally very informative session for us. And I guess we have learned a lot from it, and we look forward to work for it. So there's this one more very important question from many of our students, like what is the procedure they should follow to get an internship in your forum? So like how should they get an internship? Whom should they approach? So this question has been thrown to me from several students of our college. So they want to get an internship at your forum. So how should they do that?
Yes, there is nothing big in it. So our website is available, hrl.org. You can search in the website, and there is an internship option in which you can apply for internship online. Okay, so there is nothing. A lot of students are doing their internship with us, and I think that will be a great opportunity for people.
Can I add, please?
Yes, sure.
One line. Thank you so much to each one of you. Just letting you know, answering Shankarit, we have a mail ID which is kolkata@hrln.org. I'll repeat it to you, kolkata@hrln.org. And you can send in your CVs and interest of interning with us, and we'll get back to all of you individually. Thank you so much for being a patient participant to the meeting, and we would be very glad if we can further take this medium of interaction with the students further, and keep interacting with. Thank you especially to the Students' Union for being a big support in organizing this. Thank you to the moderators, Kushal, Shankarit. Thank you so much for being supportive. To each one of you, you have HRLN by your side. And my name is Aishwarya. Sorry, I never introduced myself. I am Aishwarya. I'm the director of HRLN Kolkata. And most of you will, I think the Student Union does have my number. There are alumni like Kushal, Shondipan, Shomitra, whose phone numbers are also there with the Student Union. And we would urge you to, link us with people who need legal help and who need our support. And we are ready, and we are very happy to help in whatever way is possible. Not only internship, but also the legal proceedings so far, and the kind of human rights violation that goes on. So thank you so much, students, and we'd like to take this forward in a next meeting whenever we are able to organize it.
and that option, that call is open for the student union also. If you feel that you need to organize more meetings on more important topics with us, we are happy to help. Thank you so much. Kushal, over to you if you want to add a point, and thank you. Please be safe, all of you.
Thank you, Aishwarya, so much. There is no everything you have spoken of, so there is no further things to add on. So thank you so much, Students Union JCCLC, so for participating with us. And we think we should conclude the meeting now because it is already 1 and the time has been exceeded. So Venkatesh.
Yeah, thank you so much on behalf of HRL in Calcutta, and thank you all the lovely people who has been there since morning. And stay safe, stay home, take care, and bye bye. Thank you so much, Apoyatati, Aishwarya, Kushal, Sundipan, and Soumitra.
Thanks.
Thanks.